Acha, 41
and
and
42, my lord. Analogous matter, my lord. Tag matter, my lord. This is, my lord, I am for the wife and my learned pending for the husband. I am filed for enhancement of the maintenance. He is for deduction. My lord, on last two occasions, her lordship Samima Jahan attempted to make a mediation. Accordingly, first mediation round took place. She heard both the side directly in person. Today it was supposed to be listed there, my lord. But mistakenly it has come to your lordship. On the earlier occasion also same thing happened, my lord. Your lordship passed an order on 23/4, right?
Yes, 23/4/2026, lordship directed it to be listed before that court, my lord. Accordingly, it was listed on 29/4. A round of mediation took place, my lord, between husband and wife in presence of Justice Sharmila Jahan. And today it was again fixed for second round of mediation, my lord. But it has again been listed before, my lord.
Mistakenly listed, wrongly listed.
41 and 42. Part Mr. A.K. Talukji for the applicant petitioner and also part Mr. M.A. Chaudhary, returning counsel appearing for the response. It is submitted by learned counsel for both sides that there was a mediation, one round of mediation took place between the parties in person in the before the court of coordinate bench, and accordingly they requested to list the matter before the said coordinate bench, learned coordinate, honorable coordinate bench of this court, so that the matter may be considering this submission made by learning counsel for both sides, the registry is hereby directed.
My lord, the date may be fixed, my lord.
Is the matter before the coordinate bench of Justice Jahan. Come to the coordinate bench, wherein the one round of mediation has already been. One round of mediation has already been taken place. Yes. 22nd. 22nd of
my
this
lord,
month.
both the side have to appear. Both the parties have,
Yes,
according to him, 5th of June will be better.
5th of June,
He has to come, my lord.
5th of June.
5th of June.
5th of June.
Obliged.
One more prayer, madam. In criminal petition 235 of 2021, there is an interim order, madam, in favor of the petitioner, madam. That may kindly be continued.
Which one? In item number?
Yes, madam. I'm 41 in item number 41, criminal petition 235 of 2021.
The interim granted earlier in case in criminal petition number 235 of 2021 be continued till next year.
I'm the
Obliged.
Wait, we don't have to. My lord, I'm sorry. My lord, recommendation item number 38, my lord. Well, the case diary is not here, my lord. I am on interim. And one more prayer, my lord, and whatever, my lord, he was directed to appear. My lord. Yes, he is from Calcutta, my lord. He could not appear because of the elections and all. Lord Lordship may extend the interim, my lord.
We cannot extend that way.
No, interim is there, my lord.
We'll extending interim. We cannot extend your prayer for appearing. Yes, otherwise, what is the position? CD not received.
CD not received.
CD not received. To reminder. Yes, when it can be?
June looks.
Yeah, obviously it will be in June only. 5th of June. We extending your interim. You try to manage. If something had happened, then you have to file an interlocutory if we don't have any.
Okay, obliged, madam.
May I present? Well, I wish to mention item in connection with item number 5. I have filed an additional affidavit, my lord. I'm
Item
paying
number
for
5.
5, my lord. Paying for my lord. Call for the record.
Okay.
And along with my lord, I am paying my lord. Kindly, this matter may be called for after some time. If within this short period of time, affidavit not come, my lord. After some time, if not come within this short period of time.
Okay, for time being.
Yes, my lord. I'm obliged, my lord.
May I please, your lordship? I beg to mention item number 19. With the consent of the other side, kindly adjourn the matter for the day, your lordship.
19 admission matter. You are for the, otherwise you are for the petitioner or for the respondent?
No, respondent.
For the respondent. You have informed the other side?
Yes, your lordship. Taken consent, your lordship.
With the consent of the other side, the learned counsel appearing on the respondent for an adjournment. Prayer allowed. We are fixing after 2 weeks without any date fixed date. It's accordingly after 2 weeks. As on a date good. Your good name?
S. Pal, appearing on behalf of Mr. A. Biswas.
In which item you are saying?
Item 19, Your Lord.
19.
Yes, Your Lord.
Acha, A Biswas. As Paul appearing on behalf of A Biswas. As Paul appearing on MS as Paul, the learned counsel appearing on behalf of Mr. A Biswas, the learned counsel for the respondent, and with the consent of the other side, in court.
Much obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 18. Lordship, engaged counsel is out of the station. Kindly adjourn the matter for
Oh, for the
Lordship.
petitioner or for the respondent?
Petitioner, Lordship.
G. Bora.
G. Bora. On behalf of G. Bora.
So have you informed the other side? Respondent side you have not informed?
No, Lord.
Because I don't get enough. Okay, we have make a note for your thing. Let us call for the respondent side. We'll see to it. Otherwise, we are praying. Make a note for your adjournment. What is your good name?
B.R. Burman, Lordship. On behalf of G. Bora.
B.R. Burman. Okay, we have taken note of it. You have to. Otherwise, if you can inform the other side, just let us know.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 35, Lordship. Sir. In this matter, Sirship may be laid down. I was in interim, Lordship,
You are
and I
in interim.
appeared before the IO, Lordship.
Your good name?
I am in, Lordship.
I mean, same modality. B. Sharma. Yes, Sharma. What is the number?
38/26 dated 19/4/26.
Okay, we are extending your interim up to 15 days so that you can appear. with
Yes,
the
Lordship,
regular-
when I received the summon, Lordship, I will appear.
That may not be the case. We have for indefinite period, the interim cannot be extended. We are extending 15 days. Let us see if we have.
Lordship.
Okay, we disposed of that.
Obliged.
Yes.
May it please your lordship, I beg to mention item number 45 on behalf of amicus DK Badya. He have received the file 2 days back only. So needs some time to prepare. May the matter be listed after 2 weeks.
Here we have received any, I don't know whether CD or scan copy, whatever its name. Item number 45.
45 is for hearing also.
I is for hearing.
Copy also Lordship, of the petition itself. Let it be
But the
attached.
state is the only party.
Yes, yes. Because it's a 2014 matter, probably that's why we do not have the record probably. Lordship.
Acha, anyway. You are Mr.
P. Majumdar on behalf of
Pardon?
amicus DK Badya.
Mr. P. Mujumdar appearing on behalf of Mr. D.K. Patel, the learned amicus, appointed for this one number for the petitioner, and the also heard Mr. B. Sharma, the additional PP appearing on behalf of state respondent. It is submitted by Mr. Mujumdar that some personal inconvenience. Mr. Patel would not appear before the court to go for the hearing. Prayer allowed is demanded accordingly after 2 weeks as on a date fixed by the registrar.
Much obliged.
May it please your lordship. Actually, regarding item number 34, perhaps case diary is not available. There's an interim order.
CD has not been issued,
Not received.
not possible.
CD not received. Issue reminder. Yes, Sharma, when it can be.
Lordship, let it be on 8th of June.
8 of 8/6 interim be extended till next date.
I'm deeply obliged, madam.
It's a regular bill, my lord. My lord, he is the recipient of one mobile phone, my lord. But today is 26 days. Can it be on Friday, my lord? Diary, my.
Why office note is there? Office note?
Correction, Lordship.
Also, some correction was there.
Oh, it has already been done.
Yes, it is already.
Okay.
So I pray, my lord, on Friday, my lord. Short. Otherwise, one mobile
This Friday.
this Friday.
Okay, well, then one matter is fixed on this Friday. It may take 1 hour,
Then
2 hour, I don't
Monday, my lord, because mobile has been recovered.
Monday, yes, Sharma, what was it?
Hatigao.
Hatigao.
Atika, okay, Monday. Monday is Monday. 25th of this.
I'm obliged.
CD before.
May I please your ladyship?
Yes.
Regular bail application, my lady. The petitioner are in jail for last 64 days, my lady. All the sections are bailable, my lordship, except section 109, which is non-bailable in nature, my lady. They are in page number 18, my lady. May I read, my lady?
Yes.
এজাহাৰকাৰী সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱাকালি 11/3/26 ইংৰাজী তাৰিখত আবেলি 4টামান বজাত আমাৰ ঘৰৰ ওচৰতে কিছুমান ল'ৰাই ক্ৰিকেট খেলি আছিল। সেই সময়ত খেলক লৈ উপৰোক্ত 1 নং আসামীজনৰ লগত মোৰ ল'ৰা শামছুল আলমৰ বয়স 24 বছৰ তৰ্কাতৰ্কি আৰম্ভ হয়। পিছত বাকী খেলুৱৈসকলৰ হস্তক্ষেপত তৰ্কাতৰ্কি বন্ধ হোৱাত মোৰ ল'ৰা শামছুল আলমে সতীৰ্থ খেলুৱৈসকলৰ লগত ঘৰলৈ আহি থকা অৱস্থাত উপৰোক্ত 1 আৰু 2 নং আসামীয়ে মোৰ ল'ৰাক হঠাৎ পদমগুৰি গাঁৱৰ বাছমিয়াৰ ঘৰৰ সন্মুখত আগভেটি ধৰি মোৰ ল'ৰাক হত্যা কৰাৰ উদ্দেশ্যেৰে ইটাৰে মুখমণ্ডলীত জোৰকৈ আঘাত কৰে। ফলত মোৰ ল'ৰাই গুৰুতৰভাৱে আঘাতপ্ৰাপ্ত হয় আৰু মাটিত পৰি অচেতন হৈ যায়। পিছত সতীৰ্থ খেলুৱৈসকলে মোৰ ল'ৰাক আসামীজনৰ কবলৰ পৰা জীৱন্ত ৰক্ষা কৰে আৰু আমি পৰিয়ালৰ মানুহে মোৰ ল'ৰাক হস্পিটেলত লৈ যোৱাৰ সময়ত উপৰোক্ত আসামীগণে আকৌ একগোট হৈ আহি আমাক আক্ৰমণ কৰে। পিছত স্থানীয় ৰাইজৰ সহযোগত মোৰ ল'ৰাক অতি সংকটজনক অৱস্থাত বৰপেটা মেডিকেল কলেজ হস্পিটেলত ভৰ্তি কৰা হয়। কিন্তু জখম অতি গুৰুতৰভাৱে 12/3/26 ইংৰাজী তাৰিখত উন্নত চিকিৎসাৰ বাবে গুৱাহাটী এপ'লো হস্পিটেল ভৰ্তি কৰা হয়। This is the affair, my lady. The fact of the matter is that, my lady, while playing cricket, my lordship, there was a altercation happened, some debate happened. Thereafter,
When he got arrested?
my lady, arrest 14/03/2026, my lady.
CD may be called for Lordship. CD will be required Lordship because.
My lady, one more important thing.
Just a
The
second.
when
Yes, Sharma.
Lordship, CD will be required Lordship because it is stated in the FI itself Lordship that he has been admitted and for better treatment he was shifted to Gauhati also. Let
No,
the
my
medical
lady-
report come. Let the medical report and see.
It's okay, but.
My lady,
he
may
is
I
in
just
custody
bring
for
on-
only 65 days.
Lordship.
64
Days.
days he is in.
He's in jail, my lady.
Yes, 64 days Lordship.
14/03/2026, I was arrested, my lady.
109 is there Lordship.
Yes, 109 is there.
Yes.
My lady, may I just bring one fact
140,
before you, lady?
Lordship.
We are not on otherwise, but only for the length of the day.
Yes.
Can be considered, it can be.
My lady, Sashit is filing lordship and call for the case can go back TCR, my lady.
Charge sheet is already filed.
Yes, my lady.
Oh, he is saying charge sheet. Since then, why are you keeping mum? You are saying this and that, and charge sheet has already been filed.
My lady, Sashit has been filed.
Can copy of the TCR be called for along with the case there? Rest will be.
My lady,
Yes,
may I
it
just
can be called for. You are submitting, going on submitting, skipping the main part. I don't know. 4/6.
In the petition, they have not mentioned that charge sheet has been.
Yes,
My lady, after that we filed with the heart.
you got the information now.
My lady, Sashit has been
What is
filed,
the
my
charge sheet
lady.
number? CS number?
This number, we have not got, we already applied for the charge sheet copy. The concerned advocate is there, my
Well,
lady.
you-
Square and case.
Call for the case record also. In one hand, you are saying that charge sheet is
We'll
submitted.
bring the
on the
charge
hand,
sheet on
you are
record,
saying
my
that-
lady. See your
Huh?
call. We will bring the charge sheet on record, my lady. You just call for that TCR. We'll bring it.
Where PCR will come, where is it, charge sheet number, how ST will do the needful? How,
Borpeta, my lady.
huh?
CGM Borpeta, my lady.
How the ST will do the needful? How?
My lady.
Where from it will call for? From which court, where from? What is the number,
lady,
what is
she
the case number,
Borpeta.
what is the CS number, how can?
My lady, Borpeta CGM code.
No, whatever, Borpeta CGM, so what Borpeta CGM? How it
My
can
lady,
be called?
may I pray for adjournment, my lady?
You file an affidavit.
I'll file an
Let
affidavit,
him
my
file an
lady.
affidavit bringing the charge sheet on
Bringing the
record.
Okay then. Bring the charge sheet on record,
Obliged, my lady.
on 4/6. Okay. Yes.
May it please your lordship. My lord, page 9 is the FIR, my lord. Whatever, my lord, to be frank, my lord, the petitioner before your lordship is a jewelry shop owner, my lord, Borni Hats. As per the allegation, he has purchased some jewelry, my lord, which turned out to be, my lord, stolen jewelry. Page 9 is the FIR, my lord.
So it was missing from the.
Page 16, my lord. Page 16, my lord. The first para, my lord.
Mm.
It is alleged that he has the lady who has stolen the jewelry, my lord, has sold it to the petitioner. That is the allegation, my lord.
This is the forwarding.
It is in the forwarding, page 16.
Yes.
Page 16, my lord, the first paragraph.
And regarding recovery, do I want to say something? Recovery is already there.
My lord, but that is not written, but possibly because the police arrested him from his shop, my lord. Because the lady told him, my lord, and he was arrested only on the basis of the statement of the co-accused, my lord.
Not recovered.
Recovery, recovery could likha nahi. It is not written, my lord, whether it is recovered or not, my lord. But my lord, he was arrested only on the basis of the statement of the co-accused, my lord, that yes, we have sold it to him, my lord.
No,
That Bonnie
obviously for the only basis of the co-accused, but whether there is a recovery
Yes.
against that, that is not here.
No, my lord. But my lord,
CD come lords.
well, he is in jail, my lord. When he was taken into custody, he was thoroughly interrogated. Then again, he was, my lord,
Now
put
see, he may be a bona fide, I won't say, may not be also. And that apart, sometimes it happens that 113 or I don't know, just forgot
Yes.
by the habitual receiver.
Yes.
That is most probably that section. It happens that sometimes if we hears the record that section is also added. Here, I'm not saying he may be a bona fide also. I cannot say. If that be the case, he arrested on 6-5.
6-5, my lord.
Let the CD come lords.
6-5, man, he was
This
taken
is
into
for Panbajar.
From Panbajar.
Then okay, then we'll call for
Lordship direct.
Monday ki tarikh. Monday 25. 25? Only
25.
this next Monday we call.
Oblige, my lord.
So to be called for and
Wait, lordship.
yes.
Regular bail, my lord. Within 1 month, almost completed, my lord. Only
Yes.
question is in this case, your lordship kindly come to page 12 is there for you.
CD will be required lords.
One the thing is about this, robbery is not applicable in case of petition.
No, we will have to examine the case dialogue because allegation is serious lords.
But only allegation is, my lord, your lordship will see page 12. That is paragraph 3rd, my lord, 3rd and 4th.
Yes.
Mufidul
Yes.
Islam, I am getting my on 18/4/26. It has come to our knowledge that the said Mufidul Islam in criminal conspiracy with Faruqi, present petitioner, my lord. Resident of so and so has dishonestly committed criminal breach of trust and misappropriated the aforesaid amount with an intention to cheat the company. Thereafter, in order to conceal the offense and mislead the authorities, he falsely reported a robbery incident at Gauhati. So robbery is something different, my lord. So far the present petitioner is concerned, my lord. In the forwarding report, you will find page 14, forwarding report, my lord. Page 14.
Yes.
Your lordship will find grounds of arrest of Farooq Ahmad. That the accused Farooq Yunus, though not an employee of the concerned CMS company, has been found to be an active participated in a well-planned criminal conspiracy along with co-accused Mufidul Islam and another co-accused. Accused Farooq Yunus, being a close childhood friend of the accused Mufidul Islam, knowing and willingly joined the conspiracy and played a crucial role in the execution of so and so. As per the statement of both the apprehended accused persons, namely Mufidul Islam and Farooq Yunus, the entire plan of staging a fake robbery was masterminded by the accused Ritul Kalita, who is posted at headquarters of so and so, Gauhati, and who assured them that he would manipulate and manage so and so, so and so. Then, acting upon the said criminal conspiracy, the accused Farooq Yunus arrived at the predetermined place at a vehicle and took possession of the entire cash amount. And this cash amount already might have recovered. Your lordship will find 7. On the basis of the technical analysis conducted the said premise, the accused Farooq Yunus was apprehended and a substantial amount of which 20 lakh was recovered and seized from his possession. So everything is seized by, I'm on that, but I'm seized by. Robbery is not applicable in case of the present petition. Other things, 60 days period, my lord. Now, if your lordship, my lord, if your lordship requires further custody, then it is up to your lordship, my lord.
If there are other stages of investigation, Lordship. Only the amount has been recovered, but as to the other parts of investigation, that has to be
Yes,
seen
yes.
by your Lordship, and he is the mastermind, Lordship. Amount recovered from him. So this is a well planned out misappropriation of money, giving it the color of robbery, Lordship. So let the CD come, Lordship. Lordship will kindly verify the statements and.
I mean, the actual robbery was not there.
Yes, but it was supposed to, given the
Oh,
shape
give
of
it
robbery,
color, acha.
given the color of.
The rest is 60 days, my
Oh,
all are
only
60.
to misappropriate.
Yes,
That has been.
yes. And Lordship, so Lordship will kindly call for the case diary, Lordship.
No, that is there, my lord. I'm not, there's my only question, your lordship, see whether you required or not further custody. Seizure list, everything, all the three already arrested, my lord.
Statement to answer.
None is there, statement also taken their statement.
Yes.
For what purpose, my only to see the city for community or it is your lordship, my lord. I live to your lordship, my lord, if your lordship.
Exactly for that purpose only, Lordship will kindly call for the case diary. If that is not the only part of investigation, Lordship. The recovery is not the only part, Lordship. Other stages are there. So let the CD come, Lordship.
Yeah, already they are in custody, my lord. Anyway,
Yes,
it is
yes, I
your
have
lordship.
19-4. Yes, 19.
Yes. 1 month custody, what remains to be investigated, my lord.
Yeah, 5. 20. At least we can give you on 26-5.
24.
Next week.
26, I am not available, my lord. If 25, from 26 onward, I may not be available.
Okay,
my lord.
25. Okay.
This will depend.
CD. Okay, we're listing it.
Oblige karo. I do. Okay.
মাটি দিচ্ছি ও হাইটস আপনি আসেন না
Please, your lordships.
we have already received the affidavit.
Yes, it has come.
Affidavit.
My lord, here, my lord, it's a regular bail application, my lord, under 483 of the BNSS, my lord. Here, my lord, lord should find the effort lord, that we have annexed, my lord, in the main petition, page number, my lord. It starts from page 16, my lord. It was lodged on 7/5, my lord,
Yes.
and there was a source information, my lord, that one Masood Jindal, he is the present accused before lordship, my lord, the person named in the FIR, my lord, that he is involved in cyber crime activities, my lord. So, my lord, that his residence and premises were searched, my lord, and he was even apprehended. And this article, lord, should kindly see, my lord, lot of articles, this debit card and mobiles and everything, but a lot of them, and most of them were in his name and in the other person's name also, my lord. So, lord should find that then page 17, my lord, and cash amount of rupees 2 lakhs were also recovered, my lord, 47, my lord. Lord should kindly say last, my lord. So now, my lord, during interrogation, lord should see that this apprehended person, he took the investigation agency to his shop, my lord, and there also, my lord, several mobile phones were recovered. He is the owner of a mobile shop, my lord. Now, my lord, then again 19, my lord. 18 shows what are the articles recovered from his shop, my lord.
Yes.
Then page 19, lord should find, my lord. Again, from a co-accused, this thing were recovered, my lord. The other, my lord, scanner and all, my lord. So, but he fled away, my lord. That lord should find page 21, my lord. The Raju Ahmed, my lord. He fled away, my lord. So all these things were, my lord, recovered.
And page 22, Lord should find that other some 4 or 5 persons' names are there, my lord. That all these persons, my lord, they are involved in cyber fraud, cyber crime, my lord. That is the allegation. Now, my lord, most pertinent question herein is that Lord should kindly see the sections of law with which the case has been registered, my lord. Here, Lord should find 61. 61(2), my lord. That is criminal conspiracy, my lord.
Yes.
That is criminal conspiracy, my lord.
Mm.
Then 3184, my lord, that is cheating, my lord. So that lordship maximum punishment is extended to 7 years, my lord. Now, my lord, 319(2), my lord, that is cheating by impersonation, my lord. That is a bailable offense, my lord.
Mm.
And my lord, 3162, my lord, criminal breach of trust, my lord. That also punishment, maximum punishment is extended to 5 years, my lord. So all these offenses, lordship saying, my lord, are less than 7 years. So here, my lord, then the next page, my lord, we have the annex the forwarding report, my lord. Page 23, my lord. I have checked and cross-checked everything, my lord. There is no reference of 35(3), my lord. That earlier 41A, my lord. Why it was not submitted? Why the non-compliance? Nothing is there. Now, my lord, the trade license we have annexed, my lord, and the income tax certificate of my lord return also. And there are some other documents like 41, 48, and my lord 47, my lord. Without going into all this, my lord, here there is absolute non-compliance of 35(3), my lord, and that lordship will show from the orders passed by the learned court, my lord, that it has been violated. Now, another aspect, if your lordship kindly see, my lord, page 37 once, my lord. When the person was arrested, my lord, and forwarded before the learned jurisdictional magistrate, my lord, the investigating agency sought, my lord, 10 days police custody, my lord, and lordship find we filed a bail application that was rejected. But page 37, last line, lordship kindly see, my lord, how the investigation was carried on, my lord. This is the observation made by the learned magistrate, my lord. I am just reading my last 4 or 5 lines, my lord. However, despite making allegation relating to cyber fraud, the IO has failed to place before this court any prima facie material regarding the contents or data allegedly stored in the seized laptops or mobile handsets. No report, extraction memo, digital evidence, or analysis relating to the data contained in the seized electronic, the next page, my lord, has been produced. Likewise, no statement or communication from any bank relating to the seized debit card, credit card has been produced so as to prima facie establish fraudulent transaction or illegal financial activity. It is also noticed that no statement of any victim has yet been produced before this court, and no satisfactory explanation has been furnished by the IO. That is the observation, but the learned court below thought it proper that let the investigation go on. So, my lord, initially 2 days police custody was granted. Why I have shown this para? Because
2 days police custody, then subsequently again another.
yes, I'll show that. My lord, why I have shown this para? Because my lord, lordship knows, my lord, first there has to be some investigation, thereafter arrest, as per Joginder Singh's case, my lord. So directly the FIR was lost, no investigation, he was arrested, taken forwarded before the learned magistrate, and thereafter sought police custody. So on the day when he was produced, there was no material as such, as it is apparent from the order, my lord, to make out the offense under the sections attributed in the instant case. That has nothing to do with, say, the 35(3), but I have shown it that there was no material on that first day, my lord, when he was produced. Now, lordship, kindly see the next order which we have annexed, my lord. Then, my lord, his bail application was rejected, but he was again given into police custody for 3 days, page 43, my lord. And, my lord, page 41, my lord, why his investigating officers prayer, my lord, why further custodial detention, my lord, custodial interrogation was necessary, my lord, that was written, my lord. Page 41, my lord. Now, my lord, normally, my lord, to see whether compliance of 35(3) or 41A has been made out or not, my lord, there are many orders passed by this honorable court, my lord, but those were, my lord, after perusal of CD, to be fair enough, my lord. But here, why I'm submitting on that? Because the rejection order passed by the learned court, my lord, magistrate court, my lord, that lordship find page 50, my lord, in the additional affidavit. That's why we have got it on record, my lord. Because that order was passed after perusal of case diary, my lord. So here, my lord, lordship kindly see page 50, my lord, that third para, my lord, that entails case, my lord, it was highlighted and placed before the learned magistrate, my lord. Now page 51, second para, my lord. I have carefully, lordship find, my lord, I have carefully perused the case record and the case diary, my lord. And on perusal of the case diary, lordship kindly say those, my lord, those 10 lines I am leaving apart, my lord, that after effective investigation, lordship seeing, my lord, around the 11th line, my lord, it begins from, it is well settled, page 51.
Yes, yes, I have seen.
So here, lordship kindly say it is well settled that the issuance of notice under section 35 of the BNSS is not an inflexible mandate applicable in every case, irrespective of the attending circumstances. Where the investigating agency records reason demonstrating necessity of arrest in terms of statutory requirements, arrest may validly be effected subject to adherence to procedural safeguard prescribed under the law. So this is absolutely a wrong interpretation because, my lord, earlier entails case, my lord, it has been highlighted any non-compliance would lead to grant of bail. And now, my lord, in a recent case, my lord, it has been held by the apex court, my lord, that in each and every case, 35(3) has to be resorted to as a matter of rule, my lord. May I place it, my lord? There are some tick marks, lordship may not take it, otherwise something wrongly we have picked. Lordship, here, my lord, that after para 30,
Yes.
33, my lord.
Yes, I have
33, my lord, I am leaving at, well, kindly see, my lord, para 33D, my lord. I am reading it, my lord. A notice under section 35(3), lordship fine,
Yes.
of the BNSS 2023 to an accused or any individual concerned qua offenses punishable with imprisonment up to 7 years is the rule, my lord. So this case has laid down the, my lord, latest position on 35(3). This order was passed on January 15, 2026, first page, lordship fine, my lord. So it is a reiteration, and in fact, it is a much more improvement or much more, it is accused centric because, my lord, earlier, my lord,
Now just read the para E.
my lord,
Para E.
E. That is after issuance of notice, they can arrest, but there has to be, my lord, there has to
Now
be
what
fresh
is E?
material.
What is E? Just
My lord?
read E.
Yes, my lord. Even if the circumstances warranting an arrest of a person are available in terms of condition mentioned in 35(1)(b) of the BNS, the arrest shall not be undertaken unless it is absolutely warranted. So here it means there are other paragraphs, lordship file. I will show, my
You
lord.
see, this case,
lord.
the nature of case itself seems.
My
From
lord.
the nature of case itself.
Yes,
seems-
yes.
It's a very serious nature of case.
My lord.
Wherein the entire cybercrime was taking place, isn't
My
it?
lord.
There are 2, 3, 4, 5 numbers under the criminal
My lord,
conspiracy.
on merit,
that
I'm
has
not
been
on that.
taken place.
I am not on the merit.
So now we, unless and until we peruse the case, what was
No.
the circumstances,
No.
under which circumstances
Yes,
it
my
got to be arrested.
Lordship.
Even without issuing a 35(3),
No,
it
my-
has to be seen.
No, my lord, that para has come up because what happens, my lord, when a person, my lord, appears after issuance of 35(3), whether he can be arrested or then also he cannot be arrested, lord, you kindly see para 30, my lord. Because there has to be some circumstances which was not available on the day.
Circumstances, there are many instances where there is obvious reason we
No,
for the
my lord,
investigating
with all-
officers, unless there is an arrest, immediate arrest, he might have pled.
My lord, with
Yes,
all
many,
respect, my,
many.
with
Because
all,
now see, you have read only one of the co-accused from which these several numbers of the laptops
My lord,
and these things are
yes,
work.
yes.
He already got
my
fled.
lord, with all
He fled
respect,
away.
my lord,
So, see the
my lord, with
situation.
all respect, my lord, can we go beyond the observation made by the Honorable Apex Court? That is why,
And not
because,
on that, but there
because,
are,
my lord,
that's why it is not a case of, so it is a mandatory, I won't say it is a
But-
rule. Definitely you have read
Yes,
this
ma'am.
para. But in that case also, there may be circumstances or the position wherein it is definitely warranted unless it is got present.
My lord,
There's
my lord,
observation of the.
My lord, I will kindly see one, my lord, that 35(6), my lord.
Hmm.
Lord, you will kindly see para 13, my lord.
Yes, yes.
Para 31, my lord. Of the same,
30, 30.
para 30, my lord.
Yes.
While making an arrest under 35(6), that is after issuance of notice after 35(3), my lord, they can arrest.
Yes.
So, my lord, after the stage of issuance of notice seeking presence under 35(3) of the BNS, the circumstances and the factors that were in existence at the time of issuing the said notice shall not be taken into consideration by a police officer while making an arrest subsequently. So there has to be fresh circumstances. Once 35(3) is issued, the person appears, my lord. Thereafter, he cannot be arrested on the material which was therein on the date when it was issued or on the date when he appeared. There has to be some fresh materials, my lord. And with all respect, my lord, we cannot give a different interpretation to the Honorable Apex Court direction because as a rule, it has to be given. Why it has not been given? It is not there, my lord. Why it has not been given? It was not there. And the learned magistrate, he cannot pass an order withstanding the order passed by the Honorable Apex Court, my lord. It is not that, my lord, that was not placed before that Honorable Court. Even if it is not placed, it must be known to the court below, my lord, learned trial magistrate, my lord, not below, my lord, learned magistrate, that this is the settled position of law as on date, my lord. And lordship would kindly see, there are so many other paragraphs I have not placed before, that 32 also, my lord, that then A also, an arrest by a police officer is a mere statutory discretion which facilitates him to conduct proper investigation in the form of collection of evidence and therefore shall not be termed as mandatory. Even, my lord, there are so many judgments in my lord, that Joginder Singh's case also, my lord, so many years back, 86 or 87, my lord, it has been held. The power to arrest is there, definitely it is there, my lord. But how to and when it has to be exercised, my lord. And here it is apparent and blatant, my lord, that, my lord, violation of 35(3) and the law of the land which has been laid down by the Apex Court, my lord. Because we cannot give a different interpretation. That is my humble prayer, my lord. On the merit, that's why I'm not submitting on the merit, my lord. These are offences maximum
Go by the, yes, Sharma.
7 years, my lord.
CD will be required, Lordship. We can argue this point at a later stage, because 41A notice is not mandatory. Notice there are offences, it is left to the satisfaction of the IOLs. If arrest is to be made or not made, that discussion is always there. The starting line of the 41A itself is clear, Lordship. So reading judgment, Lordship, one paragraph after another, we have to read the whole judgment, Lordship. If language in 41A, Lordship, is
You don't teach me how to read the judgment, then I'll place one judgment, then, my lord, kindly,
submit to the court.
my lord, with
He
all
will not
respect.
submit to me,
No,
Lordship.
no,
He cannot
you
directly
submit
submit to me.
like
No,
that.
you are submitting.
I am submitting from the
direct to me.
judgment,
Don't
line by line,
submit
that is
direct
line
to
by
me.
line.
No, no,
Kindly
don't
sit,
submit,
then-
and it
no,
is
no,
my
no,
turn.
no, my
It
lord.
is my turn.
Then
You
I-
have had your
Then, okay, you.
Yeah, just sit
I'll
down
retort,
and
my
let me
lord.
submit.
No, I may, so
No,
I will not
you
sit
do
down.
not speak to
Court
me.
will tell me
Do
to
not
sit down.
speak to
No,
me.
no, no. My lord, I'll place
Lordship,
the
it was
reply.
my turn to submit, Lordship. Why is he submitting in midway, Lordship? Why is he interrupting?
No, you're giving a
why
wrong
is he
interpretation.
submitting?
Line
Yes,
by
but
what
so
is line
you
by
have
line?
submitted whole thing wrong.
No, no,
I
you
can also
cannot
go.
be on the apex
No,
court
don't talk
judgment.
to me, please.
How can you say?
It
How
is
can you
my
say
turn,
that?
Lordship. Let him not speak to me directly.
No, 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 I'm
interrupted
speaking
him,
to the court.
Lordship. That is the thing, Lordship. The only thing is, Lordship, the people sitting here are all stupid. They are always right. They can say whatever they want against the prosecution. But if we say something, Lordship, they just jump up, Lordship. That is the
No,
prosecution.
what is against the law you cannot submit. I'll place judgment that the
That
party
is
cannot.
the interpretation, Lordship.
My
He
lord-
can submit
Yes,
his
sir.
interpretation. I can submit my interpretation. He cannot say I am wrong.
You are
That is
absolutely
the
wrong.
basic
I'll
thing.
show.
That is
I'll
the basic
show
thing.
from the
I can,
judgment.
Lordship can tell me to shut up. He cannot tell
What
me,
shut up?
Lordship.
What is this? This is wrong, my
Lordship,
lord.
I have.
No, no,
I'm
no.
speaking
Court is there to
Lordship.
monitor me.
Lordship can tell me.
Court is there to monitor me. You are nobody
He
to say
can
shut
tell
up.
me, Lordship.
How
He
can you
cannot
say
tell
that?
me. I am speaking.
You don't say shut up to me.
I'm not. I'm not
Why-
telling him
He's
shut
not
up.
Don't
I'm
say.
telling
him
him-
speaking shut up to you. He's just
Yes.
saying.
Lordship will tell me to keep quiet,
Yes,
my lord.
Lordship
Not
will say-
him, my lord.
I am not speaking to you. Lordship can stop me in my argument. Lordship can ask me to shut up, but he cannot say that, Lordship.
You are telling
I'm
me.
submitting wrong.
You are telling me. Don't repeat it again.
Misinformed, Lordship. So, Lordship, my submission is, Lordship, let the CD come, Lordship. Because the language itself is clear, Lordship. And this is a very serious offense, Lordship. The observation of the court, Lordship will find at page 41. The case that reflects that the investigation is at a crucial stage. The disclosure made by the accused during prior custody interrogation indicate the existence of a wider network of cyber criminals and crucial incriminating material. And this argument was made before the court has rejected it. So Lordship, my humble suggestion, let the CD come.
My lord, I am placing one judgment of the apex court in Antil's case that a PP should be given lessons, my lord. They must undergo training, my lord, because they cannot go beyond the observation made by the honorable apex court. In the Antil's case
He is
itself,
interpreting what the statute says.
my lord,
We are not on
Antil's
that.
case itself, we cannot do
Obviously,
it. I am placing before lordship.
Honorable
Lordship may pass necessary order.
Apex court has made the clear
My-
observation in this case
My
and
lord.
this case. Another case
My
also
lord.
is there.
Yes, yes.
So is there.
My
He is taking what the statute says.
My lord,
That is the statute.
no, my lord, we cannot, when there is an interpretation given by the apex court, my lord, that has
It's
to be
okay. We
followed
can
in
understand.
toto,
He
my
is
lord.
submitting what is
And
stated.
these sort of submissions were made before the other states, my lord. What the honorable apex court stated, my lord, I have bought that also, my lord. Kindly have a look, my lord.
We heard Mr. A. Chaudhary, the
My
learned
lord, kindly that line, kindly have see
petitioner,
once, my
and
lord.
also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent. And this is an application, the section so and so in connection with so and so.
My gra-
It is submitted by Mr. Basically, Mr. Chaudhary insisted, they submitted that, emphasized on the point that there was no issuance of 35(3) notice prior to the arrest of the accused person, which is mandatory required, and the considering the observation of the Honorable Apex Court, basically in case of Satendra Kumar until it is submitted by Mr. Chaudhary that it is mandatorily required to submit and to issue a 35(3) notice, which is the 35(3) notice before prior to any arrest, unless there is any circumstance prior to any arrest. In that context, he also cited a guideline by the guidelines issued by the Honorable Apex Court in case of Satendra Kumar until Satendra Kumar stop. He further submitted that in this present case, all the sections under which the case has been registered is punishable up to 7 years, and hence it is the 35(3) is mandatory required to be issued to the accused petitioner prior to arrest. You want to submit this one?
Yes,
also?
my lord. My lord, kindly see that page 7, my lord.
Hmm.
Para 2, my lord. Well, a counsel that produced before a bunch of orders passed in breach of judgment in the case of so-and-so, that is the Antil's case. Only a samples to show how at the ground level, despite almost 10 months, that was earlier, my lord, there are number of aberration. It is not as if these judgments have been brought to the notice of the trial courts and in fact have even been noted. Yet orders are being passed which have a dual ramification, sending people to custody where they are not required to be sent and creating further litigation by requiring the aggrieved parties to move further. This is something which cannot be countenanced, and in our view, it is a duty of the high courts to ensure that subordinate judiciary, under their supervision, follow the law of the land, my lord. If such orders are being passed by some magistrate, it may even require judicial work to be withdrawn, and those magistrates must be sent to judicial academies for upgradation of their skills for some time. Now, my lord, some other high courts and my lord, those orders which was placed before the Honorable Apex Court, my lord. Now, para 3, kindly see, my lord. Another aspect which is sought to be pointed out by the learned counsel is that not only is there is a duty of the court, but also of the public prosecutors to plead correct legal position before the court as officers of the court. Illustrations are being given once again where submission of the public prosecutors are contrary. In this case, so and so, then High Court, some observation made by the High Court is there, my lord, Honorable High Court of Delhi is there. Thereafter, kindly see Mr. S.V. Raju, learned so and so, fairly states that public prosecutors, that is the learned additional Solicitor General, he submitted before the Honorable Apex Court, very fairly states that the public prosecutors are bound to bring the correct legal position before the court, and the CBI will issue their directions to the public prosecutors in this behalf. In fact, we are of the view that all prosecuting agencies, state governments, UTs should issue such directions to the public prosecutors so that neither in their pleading nor in arguments is a stand taken contrary to the legal position enunciated by this court. The circulation in this behalf should be made through the Director of Prosecution and Training Programs should be organized to keep and updating the prosecutors in this behalf. So we are not granting of bail, my lord, it's your lordship discretion, but the law we have placed before lordship, the rest your lordship will decide, my lord. And in fact, there are so many orders passed by your lordship, my lord.
The Chaudhary Learned Counsel for the further submitted that the the rule issued by the apex court or the law plane has to be followed. Should be followed by the magistrate, the magistrate as well as the judicial PP while submitting before the court or passing the orders in that context. He also submitted the observation made by Honorable Apex Court in case of certain requirement until next, Mr. Sharma, the learned additional PP, raised objection and submitted that from the nature of case and the observation made by the learned trial court below, while passing the order reflects the seriousness of the offense, and hence, unless on without presence of the case diary, it may not be fit for without presence of the case diary. He is not in a position to submit it in regards to merit of the case. Further, he submitted that in given circumstances, there may be the arrest may be required if even without issuance of the 35-3 notice, if the circumstance or situation demands. And accordingly, he submitted that the CD may be called to know the facts as well as the merit of the case and others. Expert considering the submission made by land counsel for both sides. It is seen that privacy, it is seen that the 35-3 notice was not issued prior to the arrest of the petitioner. However, without perusal of the case diary, it is not in a position of it cannot be however, without perusal of the case diary, it cannot be held that as under what circumstances the arrest was made even without issuing the 35-3 notice, and that may reveal on perusal of the case diary, and that apart merit of the case is also to be considered before passing any order. In view of this, that the CDB call for are it in agreement if I do it? 2-6 will do?
20.
2-0. No, 2-6.
Can it be on 26, my lord?
26 may not be
With
possible.
all respect, my lord, because kindly, my lord.
26 so will be not.
We'll make a try, my lord, if possible, my lord.
It may try that.
From Boypata only, my lord, 2 hours
No,
time. my lord.
we have some difficulty on 22nd as well as
Understood.
26.
25th,
One matter related to one case may come on
Understood.
26. or
On 25th, then, my lord, with all respect.
25th is not possible.
You're from Boypata only, my lord.
Determine. 26. Okay, then 26.
Highly obliged. I'm sorry, my lord, I got
No,
it's accepted. I'm sorry.
May I please, your lordship? My lord, here in this case, my lord,
Yes.
case diary will be required, my lord.
103.
143 and 64 is there, my lord, rep, my lord.
Achha.
Already 22 days in custody, my lord.
First of June or 2nd of June? 2nd of June. 2nd of June.
Obliged, my lord. May I please, my lord?
Yes.
May I please, my lord? But in this case, my lord, my lord, the anticipatory bail petition, my lord.
Yes.
Petitioner number 1 and 2, both are husband and wife, my lord.
1 and 2.
Yes, my lord.
And yes.
2 is my lord wife, my lord. 1 is my lord husband, my lord. And the allegation is that, my lord, petitioner number 1, my lord, the husband of the attack, the husband of the wife with a dao, my lord. And my lord, specifically it is
Number
mentioned.
1 attack the husband of the wife.
Petitioner number 1,
attack whom?
husband of the informant, my lord.
Oh, sorry. Husband of the informant.
Yes, my lord.
Ayat.
And my lord, the allegation against the petitioner number 2 is that, my lord, she hold the brother of the informant, my lord. That is only allegation against the petitioner number 2, my lord. At this stage, my lord, lordship may call for the CD, my lord, along with the medical report, my lord. I am not pressing the for the interim for the petition number 1, my lord. I am only pressing the interim for the petition number 2, being a lady, my lord. Even my lord, she is the 3-month pregnant, my lord. Now, my lord, on this condition, only my lord, petition number 2, my lord. Against her, my lord, allegation is that, my lord, she
Allegation
Hold-
against the petition number 2 is lordship that she got hold of the informant's brother.
involved brother, my lord.
Informants,
Brother.
brother.
Yes,
That must be-
injured person, lordship.
Injured person was caught hold by her.
Yes, that is the
No, my lord. It is the husband, my lord.
Husband is.
Husband
injured
is my
or
lord.
lordship. The Assamese version may be read, lordship.
Assamese person. Jinap. Yes, Assamese person. Can you read? Not so lazy.
প্ৰণৱ কৰিতে বাধা দিয়াত
কি লিখিছে একো বুজি নাপাওঁ।
পুনৰবাৰ পদকীয়া কৰি দ্বাৰে
স্বামী
আৰু আগফালৰ পৰা ঘপিয়াই ৰকম কৰে
My lord, it is
আৰু ৰিংকুমণি কলিতাই ভাইটিক হাতেৰে শৰীৰত ঘাপ মাৰে মাৰ ধৰে লগে লগে স্বামীক
There is
গুৱাহাটী
some
অভাৰ
allegation against
চিকিৎসা
the
কৰা
wife.
What she did? ধৰি ৰাখে।
ধৰি ৰাখে না?
কাক?
my lord, petition number 2 hold the brother of the.
He is saying he
Yes.
gave on the brother,
Brother.
not the injured.
Not
ভাইটিক হাতেৰে
ভাইটিক হাতেৰে ধৰি ৰাখে।
ভাইটিক হাতে
And who sustained injury?
husband, my lord.
Has, yes, yes, ভাইটিক ধৰি ৰাখে।
ভাইটিক
ভাইটি is
injury কোনে পাইছে?
injured is the husband. Or who?
yes.
Anyway,
Husband has been taken to hospital. Husband is the injured.
husband is the injured. But Mr. K.M. Sunday done at counsel for the Mr. P. Sharma, Delaney additional PP, apprehension of state is an application with section so and so in connection with so and so. It is submitted by Mr. Hassan that the present accused petitioners. It is alleged that the present accused petitioner number 1 caused injury, grievous injury on the person of the husband of the informant, and it is the allegation against the accused number 2 that she caught hold the brother of the informant at the time of. If further submitted, the accused petitioner number 1 is also carrying pregnancy, and considering her stage of pregnancy, she may be granted with some interim. Next, Mr. Sharma demanded additional PP appearing on behalf of state responsible with objection and submitted that CD will be required to know the actual fact of this. Next, considering the submission made by running counsel for both sides, interim is provided to the accused petitioner number 2 till next date of 15, till receipt of the case time. However, do not find it a fit case to extend any interim protection to the accused petitioner. Okay, your number 2 will be under interim.
My lord. My lord,
And
lordship may call for injury report also.
Yes, yes.
My lord.
CD along with the injury.
Obliged, my lord, deeply obliged, my lord.
When it can be called for.
Lordship, let it be on 8th of June.
Third.
Too many cases that fixed probably.
4th of June.
4 of June, my lord.
Oh, 4th.
My lord, lordship obliged.
Date to be good, huh?
My lord, this is an 482 application. And the offense is registered under 108 of BNS. The FIR will find in page number 12. At this stage, kindly the CD may be called for.
Suicidal case. Huh? You are for how many accused petitioners?
One petitioner, Lordship.
You are for only one petition.
One.
Part D done at counsel petitioner, also had Mr. Bishop. CDB call for. Where from it has to come? Which district?
Ekajuli, Lordship.
Ikiazuli. 1st of June.
May I please, Your Lordship?
Yes.
Lordship, pre-arrest bail, allegation pertaining to the period of 2023, Lordship, 420, 23, 420, 406. Lordship, may kindly peruse the FIR, Lordship, at page 13. Only allegation is that the informant that I have received an amount of rupees 1,50,000 for getting the job of the son of the informant, Lordship, in AIMS Sangsari. And only job Lordship. And only intention of the informant is to recover the amount through police, Lordship. It is, if admitted, Lordship, it is a case of pure case of civil nature, Lordship. Is there any? I am ready to cooperate with the police, Lordship. And till that period, I am being protected, Lordship, because the allegation of absolutely false. The entire transaction was done out of a business transaction, Lordship. And if admitted, but if assuming but not admitted, Lordship, I have taken the amount. Why I have taken the amount through phone pay, Lordship, thereby leaving any evidence?
Yes, Gusam.
Lordship, taking money from giving any job, which is a serious offense, Lordship, and not returning the money also.
The allegation is obviously false, Lordship. It is admitted that I have taken the money, but
I pray for
money
case
has
die
been
at this
taken
stage,
out of business transaction, Lordship. And if the intention of the informant, as per the FIR, Lordship, only to recover the amount through police, Lordship, not the intention to putting me behind the bar. So if that's so, he has to file a civil suit, Lordship, for recovery of the amount. And I'm ready to cooperate with the police, Lordship.
Had Mr. D. Kalita Dilane, counsel for the petitioner. Also had Mr. D.P. Goswami Dilane, judicial people, bring on behalf of Judicial. It's an application, section so and so in connection. Submitted by Mr. Kalita that on the plain reading of the FIR itself, it is seen that the money was given only on business transaction, and the entire money was received by the accused petitioner also through phone pay. Thus, and full stop. Further, it is seen that the case is lost only for the recovery of money, and thus it is nothing but a civil. And thus, there is nothing but a civil dispute for which the petitioner, for which the informant can very well approach any civil forum. However, the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interim protection. Next, Mr. Goswami Dilane, the decision PP, raised objection and insisted to call. Okay, you'll be under interim protection.
Okay.
Yes, we can. 5th of June.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
Lordship, may kindly find FIR at page 10, Lordship. Allegation under section 103, Lordship.
Oh, 103.
103 is there, Lordship. Lordship, may kindly see there are 6 accused persons.
Acha.
And accused number 3, 4, and 6 are before your Lordship.
3, 4, and 6.
3, 4, and 6. 1 and 2 were arrested. The whole allegation is against accused number 1, who is the son of the accused number 3, brother of the accused number 3, brother-in-law of accused number 4, and son of the accused number 6. Accused number 1 is the son of accused number 6, brother of accused number 3, and brother-in-law of accused number 4, Lordship. Lordship, on the fateful night, Lordship, as per allegation, the accused number 1 called the victim. Actually, both of them are drugs addicted, Lordship. Both of them have consumed drugs on that day. Due to after consuming drugs, the victim went away. Thereafter, 3-4 days he was not found. After 3 days, the body of the victim was found floating in the river, Lordship. This is the allegation, Lordship. So, Lordship, the accused number 1 called him, but being addicted.
Husband of Aminu's wife. Who died?
Died, Lordship, brother of the informant.
No, name.
Name. Name is
Aminul.
Yes, Lordship.
Oh, here it is written that
Aminul.
Because former husbands of Aminul's wife is Ashraf.
Yes, Lordship. Ashraful married to a lady. She was divorced.
Okay,
Then
we
she got
call it
married
for
with
the
Aminul.
various CDP call for
Along with the PM report.
along with the PM report when it can be listed.
Part of the.
Lordship, there are two ladies.
Then
Lordship.
they are also involved, it seems, because she is the wife of this so and so.
No, no, we have no connection with Ashraful. We have stated. Well, he is not
She was
our
the
family man.
wife of so and so.
Lordship, he is not our. Ashraful is not our.
The lady, what to do? Let them come.
Lordship,
No
it's short it, Lordship.
If they are involved, yes, third date we are giving, 3rd of June.
Pardon,
Prior to the
PM, along with PM report, Lordship.
Obviously, PM.
Obliged, Lordship.
Wait, Rachel.
Yes.
Well, it's a peculiar nature. The nature of case is very peculiar. Well, the petitioner number 1 and 2, they are mother and son. Well, both of them apprehend that an FIR may be lodged against them before the Nalbari police station by the wife of petitioner number 2 and the daughter-in-law of petitioner number 1, Sabina Yasmin. Lord, what has happened on 26/4/2026? Lord, an altercation made between the petitioner number 1 and this Sabina Yasmin, and she left home. And thereafter, they received a call from the from one particular mobile number I have stated in paragraph 3. And the person who spoke to them, he identified himself to be the police. Lord, that is why they could not approach the police now without any protection from the Honorable Court. Now, the fact is that on 9/5/2026, when they were not in the house, this Sabina Yasmin, Lord, she broke the lock of the house and she entered into their home without the permission of both these petitioners. Now, the petitioner number 1 approached the Superintendent of Police, Nalbari, and that application I have annexed at page 10. Now the position is that I cannot approach for her illegality, which has been committed by her. And now the police is also not informing me whether any FIR is registered.
Why you kept 1,80,000 in your house?
Hello?
Why you have kept 1,80,000?
That 1,80,000 was out of the land sold by me that I got it from the buyer, the prospective buyer who is willing to purchase my land. And she has taken away 1,50,000, a bundle of 500. I do not know how much is the amount because I cannot access to my own house at this stage.
You cannot go to your own house. Why?
Because, my lord, if I go there, if any FIR is lodged against me, then, my lord, police will immediately arrest.
After thing is lost, I mean, you taken away 1,80,000, which is rather, I would say, the
Probably that is why, my lord, I have already approached the superintendent of police.
About the superintendent police. Why don't you send someone else for an inquiry that what had happened to the complaint lodged by you? Is there
Well,
any information? Is there any inquiry?
Well, we search for the whether there is any complaint against us or not. Whether any FIRs
against by you. The complaint lodged by you only before the superintendent of police. What is the stage of this case? The complaint lodged by you regarding
Yes,
theft and all, or recovery or robbery, whatever.
They told that they will call the petitioner number 1, but till date they have not been called.
It's very false allegation against me.
Well, at this stage, your lordship may call for a report from the officer in charge of the Nalbari police station, whether any case is registered against or not.
You are Mr. Chaudhary, no?
Yes.
Mr. M. Chaudhary, the learned counsel for the petition, also Mr. D.P. Gupta, the learned additional PP appearing on behalf of the respondent. And this is an application under section 482 BNSS, apprehending, arrest or registering of case under Nalbari Police Station. It is submitted by Mr. Chaudhary that accused there's a dispute, family dispute between the wife of the accused petitioner number 2 and the daughter-in-law of the accused petitioner number 1, and thereafter the wife of the accused no, however, petitioner number 1, Sabina Yastin, left the house of the then petitioner, and thereafter she also committed a theft in their house, and for which a complaint has been lodged before Superintendent of Police, not. But at this stage, but thereafter they are receiving some phone call from an unknown number disclosing the identity as police personnel from Nalbari PS, and for which the present petition has been filed seeking anticipatory bail. However, till date, they are not in a position to, till date they have not till that they are not in a position to say as to whether any case has been registered against them. Mr. Goswami, the learned additional PP, submitted that a report may be called for from the concerned police station in that regard. Next one, considering the submission made by learned counsel for both sides, let a police report be a report be called for from officer in charge Nalbari Police Station as to whether any case has been registered against the present petitions under the Nalbari Police Station. I will give you a short date so that you can be from where it is.
It is from
Let it be on 26, it's not 25 or 26.
26.
Yes. We are calling for it.
Hello, I'm obvious.
Please, Lordship.
Yes.
From the same FIR, Lordship, accused number 1 already filed moved anticipatory bail before this honorable court. Your Lordship fixed the matter on 21 May for CD, my lord. This matter may come along this matter.
21. What is the number?
Number is that anticipatory bill number 928/2026.
928
928.
oblique 2026.
26.
CDB call for is the matter along with AB 928/2026 on 21/5/2026.
Yes. Blessed.
May I please your lady?
Yes.
Item number 13 and 14, Lordship, I'm praying for adjournment, my lady.
13 and 14.
14, yes, my lady.
Out of same FIR, these two? No.
My lady.
Item 13 and 14 are out of same FIR?
Yes, my lady.
Out of same FIR?
Yes, yes.
Which corridor? At the request made by Planning Council, Mr. Arami, the matter is item. Matters are item list. After 1 week, you want any fixed date here?
Lordship, we'll fix, my lordship. We'll approach the registry, my lady.
Okay, then after 1 week, as on a date to be.
Yes.
May I please, your lordship?
Yes.
This is 482 application, Lordship. In this case, Lordship, the FIR will find, Lordship, page number 11, Lordship. But Lordship, and fact is that, Lordship, there is the carom board play is going on, Lordship. And between two parties, Lordship, some altercation took place, Lordship. And may I read the FIR, Lordship, page number 11, Lordship.
You can.
And with due respect, it is back to state that today on 8/4/2026, about 12:30 noon, a carom board play is going on in front of the shop of Azizur Islam at Saraljar village in connection with the carom board playing, and the cruelty and chaotic situation was arise between two parties, and first quarrel started with hand, and but while the below mentioned accused person came with lathi and rod the place of occurrence and started assaulting the Akkas Ali, so and so, and the Abdul Samad and Azima Begum and so and so, Lordship. And for which all of them got injuries in their body, and accused assaulted Azizur Rahman and Abdul Samad severely with a view to kill by life after death. Both injured persons were admitted at Solace Hospital at Gwalpara for treatment. And the injured Azizur Rahman, 4 or 5 teeth had broken and oozing blood from the wound, Lordship. But my submission, Lordship, the petitioner number 1, Selimuddin Ahmed, Lordship, and he was the place of occurrence, Lordship, and he played the carom board, Lordship. And after, Lordship, and with the four person, Lordship, suddenly, Lordship, sudden provocation is arise between the parties, Lordship, and some altercation took place. And later on, Lordship, the family members went to the place of occurrence, Lordship. In the meantime, Lordship, quarrel already been over, Lordship. So otherwise, Lordship, the contents of the affair does not reveal the person who assault and to whom first assault, Lordship. There is not, Lordship, specifically mentioned in the FIR, Lordship. But only 2 person, Lordship, and this section 109 and other 2 section is valuable, Lordship. And section 109, Lordship, attempt to murder, Lordship. That section will not come. That because, Lordship, and sudden provocation, Lordship, and there is no any intention or knowledge that, Lordship, and they will be with a plain, Lordship, to quarrel took place, Lordship. So and suddenly, Lordship, told and Southwick situation, and regarding in connection with the carom board play, Lordship. So all the family members say implicating in this case, Lordship. So my humble prayer, Lordship, interim protection will be, Lordship.
We have to wait for injury report because injury sustained by the victim is serious one, and
only, Lordship, and teeth, Lordship. But otherwise, Lordship, the family members come later on.
That regular now.
Sudden provocation, Lordship, there is no 109 will not come, Lordship.
Yeah, 4 or 5 teeth lost. That is
Lordship, that is the allegation, but otherwise it will reveal by medical report, Lordship. And sudden provocation, Lordship.
Also heard Mr. P.P. Goswami. So it is this is an application. So in connection. Considering the submission made by Mr. Hawk and the material is and statement made in the this court is of opinion that some interim protection may be provided to the present petitioner. Okay, your petitioner will be in uninterim protection. CTP call. When it can be 5th of June.
Interim, Lordship.
Yeah, interim we have
Lord, deeply obliged, Lordship. Deeply obliged. Obliged, Lordship.
May I please, Your Lordship?
Yes.
So in this case, the FIR Lordship will find at page Lordship 16. 16 is the FIR. Allegation is that, my lord, the one truck was loaded with some pan masala and zarda, and that there was driver and the 2 other persons, and that was destined to go down to the Lokhara, my lord. But the vehicle did not reach to the godown. Subsequently, this FIR has been lost, and, my lord, the vehicle was recovered at North Amingaon area, my lord, and they found that one of the handymen, there were 2 handymens, my lord, one of the handymen was found lying there in that particular vehicle in an intoxicated condition, my lord. That was the case. Lordship, my complicity, the petitioner before your Lordship is a housewife. My complicity to the offense is that, my lord, the driver of the offending vehicle, my lord, that is one Somen Boro, he is my brother. I am the married elder sister, my lord. What happened, Lordship? On 8/5/2026, my husband Rinku Chaudhary received a phone call. He is a reputed person of the society. Everybody knows him. He received a phone call from the police personnel of the Fotakilambari police station, my lord, asking him to compel the appearance of that particular Somen Boro. Accordingly, being a law-abiding citizen, my lord, on the same day at around 10 a.m., my husband took that Somen Boro to the police station. And subsequently, on the next day, that is on 9/5/2026, that Somen Boro, along with another co-accused, they were arrested, my lord, in connection with this case, my lord. The petitioner before your Lordship is Monica Chaudhary, who is the elder sister of the Somen Boro, my lord. Subsequently, the Monica Chaudhary, her husband, that is Rinku Chaudhary, received phone call from the Fotakilambari police station that she might also be implicated in this case, my lord. That was the phone call received from the Fotakilambari police station. In fact, my lord, my husband made him appear in the police station that accused, my lord. Thereafter, my lord, on 12/5/2026, my lord, Lordship will kindly come to page 18, my lord, Annexure 2. Page 18, Annexure 2. a notice under section 179 of the BNSS have been received. This notice pertains to the my lord, compelling the attendance of a witness, my lord. And the notice is supposed to be served to the person if it is a woman, child, or an infirm person, then their attendance cannot be compelled at the police station. Rather, the police official have to record their statement at their place of residence. But here, my lord, I was asked to appear. Accordingly, my lord, after filing of this application, as per my instruction on 15th, my lord, at around 11:30, I, along with my husband, went to the police station. But surprisingly, on that particular day, though I was summoned to appear there, my statement was not recorded. I was never been interrogated by the concerned IO, and they let me go on that particular day. And they're saying that if necessary, they would again call me. Now, Lordship, that is the only apprehension, my lord, that without having any role to play in the entire offense, my lord, I have been summoned to the police station. I'm ready to cooperate with the investigation. In fact, my husband was the person who was the first person to take him to the police station, my lord. Under these circumstances, my lord, I may kindly be protected. My statement may kindly be recorded, my lord. Whatever is within my knowledge, I'm ready to cooperate with the investigation of the case. Because I was married sister, I was having no knowledge regarding this incident.
Somen Boro was inside the truck.
My brother, my lord.
No, no,
He was the driver.
Driver.
He was the driver of the vehicle. He has already been arrested, my lord. And so far the
he is the sister of the arrested accused, Manboro. That's why he may be called for like, but if he's appeared and statement was not recorded, Lordship.
on 15th, my lord.
Appearance
I have a definite instruction at 11:30 we appeared. But surprisingly, neither I was interrogated nor my statement has been recorded, my lord.
It's an application submitted by Mr. Das, technical and petitioner. She is no way connected in the LS office. It is the fact that she is the married sister of the driver of the LS truck, which was stated to be missing. But subsequently, her husband received a phone call from the concerned police station to produce said Somen Boro, the driver of the LS truck, and accordingly, he was also produced before the police station, and he got arrested subsequently. But thereafter, the present petitioner also received a notice, section 179 of BNSS, and in compliance of the said notice, she appeared before the police station on 15/5/2026 at about 11:30 a.m. Without recording her statement, she was allowed to go, stating that she may be again called for if required. In that apprehension, the present petition has been lodged seeking interim, seeking pre-arrest bail. However, she is ready and willing to extend her cooperation in the investigation of this case. Next, Mr. Gusam submitted that an opportunity may be given to the present petition to cooperate with the investigation. Considering this submission made by non-constitutional persons, the petitioner is it is found that it is found efficacious to extend some interim protection in present petition till receipt of the hope you will be under interim.
Deeply obliged.
Fifth of 5/6.
Lordship, can it be 4th or 6th, my lord? 5th I will not be available.
Okay, then 4th, 6th is a holiday. 6th is a holiday, so 4th of
4th, my obliged.
Yes. Please, Your Lordship. 482 anticipatory bail application. FIR is at page number 12, Your Lordship. May I read the FIR? FIR at page number 12. May I read the FIR?
Yes.
Respected sir, it is most humbly prayed that on 24th of May 2025, the below mentioned accused person number 1, who is my friend, takes me to Gauhati to rent a car from Vrindavan Tours and Travels. Thereafter, due to anomalies in his documents, my documents were submitted to rent a Baleno car bearing registration number this, and it was taken to the house of the accused person. The car was kept for a week at the house of the accused person, and after that, they had secretly planned to sell the car, and it was kept in the house of accused number 2. On the other side, when the owner of the car called me and pressurized to hand over the car, I asked the accused number 1 to return the car, but still the accused person threatens me and asked money, stating that the car was on rent in my name. And thus, being helpless, I gave him a cash of rupees 50,000 and 70,000 online to the accused person. But even thereafter, the accused person does not return the car, and when he demanded another 50,000, I informed the police, and the police recovered the car from the house of accused number 2, Your Lordship. Your Lordship, there are 5 accused persons' names. I am accused number 1. Accused number 2 and accused number 3, they were arrested, and within 15 days, they were released. They're saying that there is no materials in the case there. Furthermore, Your Lordship, accused number 4, he was on interim protection. He appeared, recorded his statement, and then bail was made absolute, Your Lordship. Your Lordship, in the FIR, he has not said the entire truth, Your Lordship. What is the entire truth is that he has damaged one of the private cars of the accused person. Thereafter, he has promised that till the car gets repaired, keep this spare car so that I can spend my money and then get your car back, Your Lordship. In the meantime, therefore, he is paying 50,000 and 70,000, and he is using his documents, Your Lordship. It's a half-truth FIR, Your Lordship. I am ready to cooperate with the police and inform all the things to the police, Your Lordship. Other all accused persons have recorded their statement. I may be kindly allowed to record my statement. All these sections are below 7 years, and criminal breach of trust and cheating both have been implicated, Your Lordship. However, it's just a case of maximum breach of trust.
Case diary Lordship at this stage because
Your Lordship, moreover, in page number 28 of the last anticipatory bill order, in paragraph number 4, it is stated that the stolen vehicle has already been recovered, Your Lordship. My custodial interrogation may not be required at this stage.
the petitioner who rented the car vehicle and he demanded money again. So at this stage also I pray for case diary.
It's an informant, sir. Informant has rented the car, and then he's saying that someone else is demanding money for the car he has rented. The story also does not match his FIR. May I be kindly protected, Your Lordship, so that I can record my statement? Your Lordship may also kindly see page number 23, where 2 persons were arrested, and on the 15th day they were granted bail. It is also mentioned there, considering the facts and circumstances and materials available on record, I am of the view that further detention of the accused person is not necessary, which means it's simply a technical case where half-truth FIR has been given. May I be allowed to?
50,000 and 70,000 was given to the owner.
No, Your Lordship. 50,000 and 70,000, the informant gave the accused person number 1, who was the middleman for the repair of the car, Your Lordship, which the informant has damaged. This is a different car, Your Lordship. And in return, he has hired this car.
Asked the petition accused number 1 to return the car.
Indeed, Your Lordship. He was at fault, and then he changed the narration, Your Lordship. And he's in his own name, he has taken the car. I have accompanied him. He is my friend. Everything is mentioned in the FIR. But it is not mentioned why he rented the car.
So as per you, what is the story?
Your Lordship, he damaged a car of the accused number 2, and then he said, keep this car, till that car I will repair on my own money. And thereafter, he met other people, and then he changed his mind that it was a kind of accident, so I'll not repair the car. In the meantime, he paid the money for necessary repair. Around 1.5 lakhs was the total money to be repaired. He paid 70,000, 50,000, and the rest of the money he does not want to pay. And also the car which he has hired to give to them for keeping it for the time being, he wanted it to be returned also. He basically got influenced by other persons in his friend group, Your Lordship. They are all friends of the same group, Your Lordship. And already 2 of them are on bail. One has been granted anticipatory. He recorded his statement. He received his anticipatory as an absolute also. May I also be kindly allowed to? May I kindly be allowed to cooperate in language?
This is an application. so in connection with this. Next point is submitted by Mr. Muscat that the present accused petitioner is the accused number one and accused number one. With some false and concocted allegations, the affair has been lost. Full stop. However, it is a fact that the informant had damaged the vehicle of the accused number two, and he assured to repair the same. And during that period, he asked the accused persons to keep his vehicle in their custody. But subsequently, and he paid, and it is also admitted that he paid rupees 50,000 and 70,000 in 2 installments for sake of the recovery of the repairing of the vehicle. But thereafter, he changed his story and lodged the FIR with some concocted allegation without handing over the damaged car. However, the petitioner is ready and willing to cooperate in the investigation of this case if he is granted with some interim protection. Mr. Sham some additional PP raised and submitted that city may be called for to know the actual fact of the case, wherein the allegation of to know the actual fact of the case, considering the allegation brought in the. Okay, you'll be under interim protection.
I'm deeply obliged.
5th of June.
Deeply obliged.
ইকুয়ালটো একে চিম্বলত দেখুন কিয়নো
কিমান
তোমালোকে
item number?
তুমি থাকিলে জিঅ' থাকে সি থাকিলে তুমি থাকা
Yes,
May I please, Your Lordship?
we have received here.
Yes.
Is there? You are for the informant? Okay.
Otherwise,
Yes.
Lordship, on last occasion, the affidavit was filed, we have filed the affidavit, Lordship. Last order it is reflected to, we have put to amend the cost title, Lordship. The informant name was wrongly included in the
Acha,
petition.
informant
It
was
is-
deviated. So you are now for the informant or for the husband?
No informant, Lordship.
For informant.
For the informant earlier, Lordship.
Okay. So he is for informant.
And Lordship, the fact of the case is that, Lordship, the victim and the present petitioner was taken into custody on Patwadi, Haryana, Lordship. They were there, and the victim was recovered from the Haryana, and upon a transit remand for 6 days, the petitioner was brought to the jurisdictional court. Then he was produced before the jurisdictional court, Lordship, and he was arrested on 23, 26, and as of date, Lordship, it is 59 days behind the bar, and the offense is also 60 days offense, Lordship, and the victim was also recovered in the victim was also recovered there itself, Lordship.
Yes, this recover her statement is also recorded.
Lordship, her statement.
Statement already recorded. So she is recovered.
Yes.
So basically you are on the length of detention.
Yes, Lordship.
Very formal. Rupam? Even to this. Nasıl Rupam abi? আপনার গাড়ি এসেছে
কম বেলেন
ঠিক আছে তো অসুবিধা হয়েছে বুঝি পাইছে Yes, so you're basically on the length
of detention.
detention.
Maybe 59 days.
9 days. you're saying.
59 days, Lord. Lordship will find the date of arrest on 47 notice. After then, he was produced before the Patwadi Haryana court, Lordship's CGM Judicial Magistrate First Class. Haryana, Lord. Which is on page 13, Lordship. And notice 47 is on
Page 20, 22 and 23.
Where is the order? It was on transit.
Lordship, it is on page 13, Lordship. The prayer is there, Lordship. We have only found a prayer, Lord.
Achha.
Prayer made before the JMFC Haryana, Lord, Patwari, Haryana, Lord.
Yes, Sharma.
Lordship, this statement is present, Lordship. Lordship will kindly use the statement.
No, because then we will settle law. Petitioner and me law. I have no option. Your law.
Petitioner is Ajit.
And for the informant.
She directly brought an allegation against that Ajit.
Yes. She was married to Ajit, Lordship, without her consent. But thereafter, Lordship, the later part of the statement, Lordship has seen. So, Lordship, how it has been amicably settled, I don't know, Lordship, but
What kind of settlement?
No, Lordship actually, because.
No objection. I can understand what kind of settlement you arrived.
Because there was a love relationship.
With whom?
As per instruction, Lordship.
No, with whom? With whom?
Between the petitioner and my daughter,
No, but he says otherwise.
Lordship.
he didn't have any love relation with the petitioner. Petitioner is Ajit, na?
Yes.
He is
And
Ajit.
one more thing also may be noted, Lordship. In the FIR itself, the informant has stated that the mental uh, health of the victim is not good. Lordship, in the FIR itself, it is there. Whether that was taken into questions while recording the statement or not. In the FIR in page.
No, that is also already taken care of. That part is already taken care of. By certificate is also there.
And instruction issued actually not to proceed the case now, Lordship. Lordship,
No, you are saying love relation with whom? Love relation with whom? With the petitioner.
Lordship.
There's no thing about this part about the petitioner love relation.
My information received from the informant, Lordship, actually, instruction.
Who is the informant?
Informant is Lordship, Nusirazan Nessa. Nusirazan Nessa.
Association, some money was given. But obviously, he had something was there, but subsequently when he came to know that they have not sold this actually irrevocable, then he immediately informed the parents. That part is there. You were in behind the bar how many days?
For 59 days from the date of arrest.
In addition of any is there till date? Section added?
No, Lordship.
No, it's not. Had Mr. demoted in an also heard. Mr. Bishop, Tilane Edison, appearing on behalf of state respondent, and Mr. S. Hussain, Tilane Council, appearing for the informant. This is an application, the section students in connection with students. CD received with the same. It is submitted by Mr. Mehdi that the present accused petitioner is innocent, has not committed any such offense as alleged in there. However, both the petitioner and the victim were apprehended in Gauhati, Haryana, and from where she was brought for recording her statement. And the accused petitioner was also proof on transit remand, and thereafter he was produced before the consent court. The accused post of the accused petitioner is in custody since last 59 days, and hence considering his length of detention, he may be released. However, the petitioner is still ready and willing to extend his cooperation in further investigation of his case if he is granted with some interpretation. No, if he is granted with the granted with the privilege of rearrest. Mr. Sharma, the learned additional PP submitted in this report. That the statement of the victim has already been recorded, wherefrom it reveals that some physical relationship was there with the present accused petitioner during her stay with him. However, he submitted that till that there is no section is added, nor any prayer is made by the eye. Next, Mr. Hussain, the learned counsel appearing for the informant, submitted that matter has amicably settled between the parties, and the informant has no objection if the petitioner is granted with bail. Considering the submission made by the counsel for without going detail into the merit of the case, and considering the statement made by the victim under section 1 of the PNSS, and we service the length of detention already undergone by the accused petitioner. This court is of opinion that further custodial is bill number is submitted that further it is of the opinion of the court that further custodial interrogation may not be necessary for the purpose of in view of this, I find it effective. It is of which police station?
Lordship, Nunmati police station.
Nunmati, to the satisfaction of CGM government. Okay.
Livelihood.
25.
May I please, Your Lordship.
It's 25 received, we,
Yes.
Lordship, and a regular bail application, Lordship, FIR will find page number 9, Lordship. Lordship, and there, as per the FIR, Lordship, there are 4 days, Lordship, and one person, Lordship, is stealing some boiler chicken from the informant shop, Lordship. And that is approximately amount 10,000, Lordship. But on the, as per the FIR, Lordship, on Lordship, on 30/4/2026, Lordship, in the morning hour, Lordship, and he is coming by one motorcycle, Lordship. And they presume that and he is coming for theft, Lordship. On that basis, he was caught red-handed and handed over to the police after assaulting him, Lord. So, my lord, and apparently, Lordship, I have enclosed the Lordship seizure list, Lordship. There is nothing has been recovered from his possession. But only his motorcycle has been seized and nothing has been recovered. So only 10,000, it is doubt approximately, but there is not a specific, Lordship. So, my lord, as on today, 18 days in custody, Lordship. Boiler chicken, but otherwise, Lordship, and he is the delivery boy of the boiler chicken in a farm, Lordship. For last 10 years, he is driving the vehicle of the boiler farm, and he's a delivery boy, Lordship. And there is dispute is also, Lordship, and the informant is the boiler shop owner, Lordship, and he is supposed to be pay 8,000, Lordship. That is, I am very clearly mentioned, Lordship, in page number 5, Lordship. And in this regard, there was some dispute, Lordship. Well, 18 days, Lordship, and nothing has been recovered from his possession.
Here, Lordship, the incident as it is narrated, that is the incident, Lordship. The local people caught him, Lordship. He was entered into the shop of the informant and was on the process of stealing the broiler chicken. And Lordship, it amounted to around 10,000. He had done it earlier also, Lordship, as per the statement of the complainant. And that is the case.
but on that day he could not.
He could not.
He was caught red-handed.
Yes.
Pardon, Mr. Epoch, the learned counsel petition, pardon, Mr. Petition, the learned litigant Apprehension. It's an application, section swells in connection with CDDC. It is submitted by Mr. District is innocent and with only on suspicion the FIR has been lodged against him. However, it further submitted that accused petitioner is a delivery of chicken, and on that day also he came for delivery of chicken, but on suspicion only he got arrested. So nothing has been seen of it. Mr. Sharma, the learned he submitted a statement that from the FIR it is said that in earlier occasion also he committed theft in the said boiler farm, and on the day of the incident he was supposed to commit theft in the shop of the farm when he got raided. Next, from the during the submission by the counsel and also paid the case that considering the medical evidence, the case that period of detention already indicated. This court is of opinion that further custodial verification may not be necessary for purpose of testing. Accordingly, this court is of opinion that the petitioner is entitled for privilege. Wherefrom it is position.
Lordship. Judicial magistrate deeply obliged.
36.
We have reached.
CD has been received, Lordship. The injury report has not been received, but Lordship, I have talked to the IO today morning, Lordship. They have stated that the injury is simple. Only the
Scuffle,
Lordship.
He is a video journalist reporting up from outside the police station. The home guard was recording their reporting. They said that we are reporting for the nature, why you have to record us. That led to a alteration. I respectfully submit further custodial detention may not be necessary.
The only thing, Lordship, I have to submit it, Lordship, because he is involved in another case which has already been charge sheeted. That-
And I have been
That
granted,
particular journalist.
yes, I was granted a anticipatory bail. And in the cross case, the opposite party was arrested and kept in jail for 3 months. He, he goes and report on those disputed place.
Ask him not to go.
Like, someone has to take the lead, others
Any
stand in
obvious-
front.
That is the duty of a journalist. But should be true.
Careful, he has to be careful, man. I have told his wife in the morning that ask your husband not to be so brave. Send the others.
He collect the news for any
Yes,
any paper or any
page 20,
page 20.
identity card, man.
It's
Potimamba life, man.
removable line. Part Mr. B.T. Font, Learned Senior Advocate, assisted by
P. Dole.
P. Dole, Learned Counsel for the petition, and also had Mr. P. Shah, Learned Additional Leave, appearing on behalf of State Respondent. And this is an application, section so and so, in connection with so and so, CD receipt by Mr. C. Next paragraph. This is submitted by Mr. Font, Department for the petition. And the present is the fact that the application and scuffle took place while the petitioner, as a video journalist, was taking some videos and photographs of a home guard. But apart from that altercation and scuffle, no other incident had taken place, as alleged in the FIR. He is a journalist who is presently working under Protibimbo Life and Protibimbo Life. However, the accused petitioner got arrested in connection with this case on 5/2026. Thus, the IO got sufficient opportunity to interrogate him, keeping him in custody. Next, Mr. Sharma, the learned additional PP submitted in this regard that the city received, but the injury report is not available. However, on telephonic communication with the IO, he reported that the injury is of simple in nature. However, Mr. Sharma submitted that another case was also lodged against the petitioner, petitioner for the similar kind of offense. Next, in that context, Mr. Bond, the learned senior counsel, submitted that that in the said case he already already obtained the anticipatory bail, and the cross case lost by him is the accused in the cross case lost by him is already in custody for 3 months. Next, considering this submission made by learned counsel for both sides, I have also paid case diary. Considering the metrics available in the case diary, this is the report received from the IO regarding the injury. This court is of opinion that further custodial interrogation may not be necessary for purpose of investigation. Okay, you'll be under in bail. Jaluk pade na?
Jaluk.
CGM Kamur.
Deeply appreciate.
Please, my lord.
Yes, 27 year receipt.
Scan copy was called for.
Oh, scan copy was scan copy to pass.
My lord, I have received the summon copy and appeared lordship, trial court lordship, and I have.
Oh, already? Okay.
Petitioner is Santosh Mili.
Santosh Mili, lord.
Yeah, already you have it.
Yes, Lordship, already available.
Part Mr. Dilane petitioner. And also part Mr. Bishop Dilane petitioner. State response. This was an application seeking pre-arrest bail in connection with connection with Borborua, yes, case number 97 of 2025, which was subsequently charge sheeted by CS number 111/2025, dated 30/12. However, the interim granted to the present petitioner was also extensive till date, and it is submitted by Mr. Doctor that in pursuant to the order of this court, they have already appeared. The accused petitioners have already appeared before the learned trial court below with an application for bail, which was considered and allowed both the accused persons to go on bail, executing upon to the satisfaction of the concerned. In view of this, the present anticipatory bail application has already become infructuous and accordingly disposed of. However, with a direction to appear before the learned trial court below regularly on each and every two weeks.
Highly obliged, Lordship.
28 Lordship, petitioner is on interim and CD has not been received.
Not received.
CD not received.
May I please, Lordship?
CD is not received. You are on interim, I think.
Yes, ma'am.
What is BA 191?
That was BA. Out of this affair, two persons arrested, man. And they have got
That
the
was
bail, man.
arrested.
Yes, man. In fact, his role is nothing. The present petitioner, he's an old person, man. And he's the relative of both.
Mr. Sharma will submit something. I think we are extending your interim. CD not received. Issue reminder. Yes, Sharma, but when it can be?
Lordship, let it be on the 9th of June.
9th of June. Okay. Interim be extended till next day.
29.
Lordship, here, Lordship, the CD has been received. Petitioner is on interim, Lordship. We have to update the CD, Lordship. Because
In terms
earlier,
of the interim order granted, I appeared before the statement has been recorded.
from the month of April, Lordship, it is not updated, and some report was called for, which is not in the CD, Lordship. Key report.
Some verification regarding the circulation
Yes.
in the social media.
Yes.
His mobile phone was seized, my lord. On the other day, that learned PPS submitted that it was verified, my lord. After verification, that mobile phone has been returned to me, my lord. My instruction.
But verification report is
My
not
lord.
before us.
I mean, in time, date may be fixed.
It is updated till
21/4.
but your interim was on
9/3, my lord.
9/3. In
9/3.
that case, so it should be available, but it's not available.
It is not available.
But as per your instruction, your petitioner has already appeared.
Yes, ma'am. That is in the receiving. That is in the.
Yes, appear. That is there.
Oh, that is there.
Yes.
But you need the updated one.
Oh, yes, only for that report, Lordship.
Oh, you have already appeared.
Yes, ma'am.
Okay. Heard Mr. P. Hajarika, the learned counsel for the petitioner, and also heard Mr. P. Sharma, the learned petitioner, appearing on behalf of James. CD received and but it is submitted by Mr. Sharma that updated CD will be required as the report which was sought by this court by order dated 24/04/2026 is not available in the case. In view of this, Mr. Sharma submitted that this you want to return it back
Yes,
or
sir.
return? Want
Correct,
to
correct.
return back the case diary, calling for an update. Next para, Mr. Hazarika, however, submitted that after obtaining the order of interim period as well, the accused petitioner has already extended their cooperation and his statement is also recorded by the alia. In view of this, let the CD be returned calling for an updated one with the report which was sought by this court. And matter may be fixed, yes,
12th of June.
12th of June. 12th of June, interim be continued. with next.
Public.
Lordship, petitioner is an interim. There are 3 numbers of petitioner, Lordship. The only thing, Lordship, this is a case of cross FIR, Lordship, between the husband and wife. They are the family members of the husband. Now, Lordship, the wife has lodged the FIR that her minor daughter, Lordship, has been kidnapped by this petitioner's, Lordship. But, Lordship, they have appeared before the IO. The only thing is, Lordship, I have talked to the IO also, the victim child has not yet been recovered. Both the parties, Lordship, the mother side is saying that the child has been abducted by them, whereas the father side they are saying that the mother herself has abducted the child. So now, Lordship, they are on interim. I am praying, Lordship, the CD may be updated for further investigation, Lordship, because the victim child has not been recovered.
Till date, there is no recovery.
No recovery. They have appeared, Lordship. That is their, Lordship. But for further investigation, Lordship, kindly update the CD. Allow us to update the CD.
Lordship, subject to submission, my learned friend. Lordship, the prime accused, the father, he has already been granted bail by this honorable court. This is page 7.
We are not.
No, Lordship,
That was
yes,
PA, Lordship.
because the present petitioner is cooperating. They are the brothers of the prime accused.
Lordship, I am not praying for
No,
vacating the
Not,
order.
he is not praying for that manner, he is not submitting on merit also.
Yes.
He's saying that the cross FIRs are there, very counter allegations are that the child is abducted by this party
Yes.
or by that party.
Yes.
This is a counter allegation.
Yes.
His only submission is that child is not
Yes.
yet recovered,
not yet
so
recovered.
needs some updation.
Yes.
That much only. Otherwise, your cooperation, we are not disputing it. You have already cooperated. That is not disputed. Heard Mr. H. Ahmed,
Medical-
Leland, and also heard Mr. B. Sharma, Leland, additional BP. CD received, however, it is submitted by Mr. Sharma. That the petitioner, no, CD received and it is and it is submitted by Mr. Sharma. That the petitioners have also cooperated in the investigation of this case. However, it reveals that there is a cross cases between the parties where there is a abduction of a child who is not yet recovered by police. In view of this, Mr. Sharma submitted that the CD needs to be updated and with a note of the IO in regards to a note of the IO, note of the IO as to whether the child has already been recovered. In view of this, let the CD be returned, call for an updated one. However, the interim granted to the present petitioner will be extended till. Yes, Sharma, when it can.
Lordship, let it be on 12th, Lordship, 12 June.
12th of June. We are extending your interim up to 12th of June, and there is no dispute that you have cooperated.
31 also, Lordship, I have a similar pair. Here also, Lordship, the petitioner is an interim, but the medical report is not in the case that it has not been collected as of yet because the grievous injury, attempt to murder sections are there. And the statement of the witness also states that he was given a fatal blow, Lordship. But the medical report is not in the case diary. So Lordship will kindly allow us to get it updated.
So 118 is there.
Yes, 1182 is there and 109
9 is also there.
Yes. Only for that purpose, Lordship.
You are Mr.
Jaman.
Heard Mr. N. Jaman, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state response. It is submitted by same prayer. It is submitted by Mr. Sharma, the CD received, but its need for updation as the medical of the injury report is not available in the case diary, which will be required for the disposal of the same. In view of this, let the case diary be returned, calling for an updated one. Yes, Sharma, when it can be, along with medical report of the injury.
12th of June. also.
12th of
Interim order maybe.
12th of June, interim we continue till next day. Otherwise, what is your instruction? They have already appeared?
They have appeared, statement was record.
Cooperated.
Obliged.
CD received, Lordship.
May I please your lordship? One calf was stolen, lordship, and recovered. And lordship, in the forwarding report, lordship may kindly peruse page number 16. Page number 16, ground of arrest, point number 5. The accused person has been caught red-handed. This accused person was arrested and the calf was recovered. And my name is entangled in this case, lordship. I was on interim, I appeared, statement recorded. Lordship, any, it may be.
Who are you in fact? You are not related or who are
Not related with the case. My name has been, most probably the main accused has taken my name, therefore my name has been entangled in this case. Otherwise, my lord, in the FIR, also,
You are
lordship,
Jalalur.
yes, my name is also not there either in the FIR
Jalalur, yeah.
or in the forwarding report. The main accused arrested, he was caught red-handed.
2% here.
Lordship,
2%.
2%.
2 persons. I'm in interim.
They are on interim, Lordship, and the CD we have received on 16/5. But the statement of their petitioner are not in the case diary, Lordship. There is no note if they have appeared or not. There is no.
Your
note, Lordship.
interim, it seems to be obtained on 31/3.
Yes, Lordship, on
31st of March.
31st of March.
There is no
Then
note.
why you have not appeared?
Appeared, Lordship.
There is
To
no
my
notice that
instruction.
you have appeared.
মিটিং পোৱাৰ পিছততো মই নাজানো, যোৱা প্ৰশ্ন নাই।
নাই, সঁচাকৈ নাই।
নাই যদি
মই
আপডেট
সেইটোৱে ভাবি আছো interim নাই বুলি। ৰাতিপুৱা নাই। In that case, Lordship, let it be after 1 week, we'll just verify. Otherwise, the offense is of stealing 1 cow, but whether he has appeared or not, Lordship, it is not
We'll do
clear.
one thing then. If there is no note at all, then they will be not in a position to say whether he
Yes,
have appeared
yes.
or not. Sometimes it happens that appeared, but not recorded. That
Yes.
is different.
It happens, Lordship.
It happens sometimes.
But sometimes, Lordship, the order is always in the case that.
Yes.
Yes.
Huh. That is also not
That
there.
is also not there.
Then how can we say the order which was passed for your interim, that is also not there in the case that.
Yes. I was searching for that
Let
also.
it be updated, Lordship. And my interim may be
No,
continued.
your interim question is different, but you have not appeared.
Appear. To my instruction, they said they appear
see-
because on 31st of
Now see, you are
March.
saying that appear, but obviously there's sometimes that Mr. Sharma is also agreed to, it may not be recorded. That is different, but your order is also not available in the case that. That should be there. That is the one proof.
It is beyond my control, Lordship. What
Why beyond in control?
what they are doing, police is investigating what the things are there or not. It is beyond my
You
control.
should instruct them.
I am appearing on behalf on my client's behalf.
No, you should instruct them. That's what I'm saying.
On 31st of March, when interim was granted,
Yes.
immediately I applied copy, sent to them. I telephonically called them to appear within such and such date. This is as a lawyer, I have to do this, and I have done in every cases, Lordship.
Lordship, may fix it on Monday, Lordship. I will take instruction if they have appeared or not.
What I'm saying, Monday it may be fixed. But suppose in any case they have not appeared or they are not recorded, then so it has to be.
Yes.
So let it not be fixed on Monday, let it be on 1st
Yes,
of
yes,
June or 2nd of June, so that they can at least appear.
Lordship.
That's what.
Then we'll update the CD, Lordship. We'll
Yes, obviously. Heard Mr. G. Soma, the done counsel for the petition. Also heard Mr. B. Sharma, the done additional appearing on behalf of state respondent. It is submitted by Mr. Sharma that the CD received, but the statement of the accused petitioners are not available in the case diary. And the order of interim granted to the petitioners are also not available in the case. Next para, in that context, Mr. Soma, the learned counsel for the petitioner, submitted that as per his instructions, the accused petitioner have already appeared before the IO, and their statements are also recorded after obtaining the order of interim pre-arrest. But as the statements are not available in the case diary, next para, case diary, the CDB returned calling for an updated one with a direction to the IO to furnish the statement of the accused petitioners if already recorded, and further the petitioners are hereby directed to appear before the IO within 7 days from the date of order, if not appear or their statements are not yet. Let the matter be accordingly listed.
15-6.
15-6.
Obligement.
And by 15-6, interim be continued till next year. Ask your petitioners if they have not appeared, then ask them to appear, because thereafter there will be no interim, it will be automatically vacant.
Obligement.
Dear Lordship, FR has been submitted.
FR submitted.
Yes,
So no case at present.
no case.
FR. Yes, what is the FR number?
8/26,
8/26.
dated 29/4/26.
You are Mr.
Zed Rahman.
Jed Rahman. We are on which number item? We are on post. Jed Rahman. Then counsel for petition. Also heard.
That is the report.
And also heard Mr. B. Sharma, the learned additional PP, appearing case was fixed for case diary. However, it is submitted by Mr. Sharma that case has already ended with FR. Ended with FR number 08/2026, dated 29/04/2026. In view of this, the present anticipatory bail has become infructuous, and accordingly the same is disposed of, and the interim granted to the petitioner also hereby stands vacated. The WT message received from the IO be kept as part of it. With the above observation, the AB is
15 May. 36 Lordship has directed us to get a report if any case has been registered against him.
Yes,
We have
what is
received
the
a report, Lordship. No case has been registered.
no case. Heard Mr. R. Amin, the learned counsel for the petitioner, and also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of the respondent. Next, para report received from the from which police station this one is?
From
Algasia police station.
All Garcia. We have received from Borpeta only. It was from Kolgasia. It's from Kolgasia, Mr. Sharma.
From
Because Kolgasia PS is different and Borpeta Sodor is different.
Lordship, they have mentioned as Borpeta.
The superintendent of police was Borpeta, but the
Yes, from Borpeta, they have filed one representation before the SP
superintendent of
Borpeta.
police regarding the either any, as because the Kolkata police station did not giving either any FIR has been registered or not. So
But thereafter they have made a representation before SP.
Thereafter made the SP to either any non-cognizable offense.
Obviously, it has to be received from Kolgasia.
Kolgosia. Then Lordship, I will have to take the report from
Report
Kolgosia.
submitted that one report is received from Borpeta PS, wherein it is reported that no case has been registered against the present petition. But on from record and from the submission made by learned counsel for the petitioner, it reveals that they are suspected to their apprehension of registering a case under Kolgasia police station, Borpeta, or Kolgasia police station, Borpeta, Tamane Borpeta Victor there, and not from the not in the Borpeta Sodor police station. In view of this, let a fresh report be called for from Kolgasia police station as to whether any case has been registered against the present petition. Yes, when it can be.
As your Lordship, direct.
1st of June, so and so, interim be continued till next date of listing.
Deeply obliged.
CD received, Lordship.
It's that they are not appearing. CD received here.
CD received, Lordship. Petitioner is on interim.
We are going to retain the case date for some time. or
Lordship,
it-
second approval.
Now we can call for again.
I leave it to you, Lordship.
We don't know. In 26, we are listing some less numbers of matters can be taken.
Lordship.
None appears on call for the petitioner. However, it is submitted by Mr. Sharma, the learned additional PP that CD receipt. Retain the case diary till next set of listing. List the matter on 26/5. Interim be continued till next set. Done.
Please, may please your lordship. We have not received any copy from the petitioner.
You are for the respondent.
Respondent number 1.
No, in the morning hours, actually, one MS BR Burman, she appeared on behalf of the engaged counsel G. Bora.
Yes.
And she submitted that due to some personal inconvenience, G. Bora is not in a position to argue the matter. So the morning hours only by adjournment prayer was made, but it was not informed to UI. So we kept it. So now we are saying that you have not received any this copy. Hard MS Dear Bourbon, done it counsel appearing on behalf of MSG Boda, and also heard you are Miss
D. Goswami appearing on the
D. Goswami.
D. Goswami.
D. Goswami appearing on behalf of
R. Goswami, but he will
Mr.
not
R.
appear.
R. Goswami for the respond number 1 and submitted that they have not received the copy of the petition till date. In view of this, the petitioner is hereby directed to furnish copy of the petition during the course of the day or within 2 or 3 days. Let the matter be accordingly listed.
The R. Goswami will not appear in this case because he has been appointed as a special public prosecutor.
Then if their name is MS N Devi is also there.
NDB and D. Goswami.
So now you are appearing on behalf of NDB now.
NDB.
NDB. Miss D. Goswami, R. Goswami, colony, NDB. Okay, we'll record the name of NDB. Gurung-gurung like a
Lordship, here we need to file a reply of the affidavit in opposition filed by the respondent, Lordship.
You have already filed or what?
We need to take some instruction from the client. Some more time is required, Lordship.
Lordships, I have a small prayer in this matter. Your Lordship will kindly peruse the order of the passed by the learned principal judge.
There
Number
is
one,
nothing
it
to
is
go through the order.
just 1 minute. Let me finish. It is an interim order. It's an interlocutory order. Number one, this petition is not maintainable at all on the ground. Your Lordships is aware of the legal position. I do not need to apprise your Lordships about the fact that interlocutory orders are normally not entertained in criminal revision petitions. In any case, we have filed a very small objection, and irrespective of whether they want to file a reply or not, I just wanted to point out one thing, that there was a categorical direction by the Honorable Family Court that he has to pay me the arrears within a period of 4 months. The 4 months have already elapsed, and there is no interim order in this petition. Your Lordship.
There is no area.
There is no-
Lordship.
there is
There is no area in my case. I have no area because if you go to the order dated 17/3,
There is no area.
no area, Lordship.
Lordship, the order is from the date of filing. The arrears is almost 2 lakh rupees.
No, Lordship, if you go to the order, this is trying to mislead the court. There is 17/3/2026. If you read, Lordship, the learned counsel for the petitioner has submitted that he is under instruction, the given petition regarding the payment of the maintenance from the date of filing of the petition. However, the petitioner is not adverse to pay the amount from the date of adverse to pay the amount from the date of order. I was directed to pay the amount from the date of order, Lordship.
Which date are you reading? Which order is this?
17/3/2026, para number 3, Lordship. Specific direction was given by this court.
Where page number?
It is an order
Order
Order of
this
73
case itself here.
by this court.
By yes, Lordship.
By this
By
court.
another court, Lordship.
Whatever,
Yes.
by this court.
Yes, this
I'm
court.
not
Lordship.
checking whether coordinator or what, but anyway,
Yes.
this court.
Yes, yes.
17/3.
17/3/2026, Lordship.
17/3. 17/3/2026.
Specifically written, Your Lordship. From the month of January and February 2026 within the period of 15 days. Further, I have also filed an additional affidavit bringing on record that I am regularly paid for the month of March, April, as well as for the month of May.
No, this is the
the submission of the
He
petition.
is submitting the
Next.
No, where is the order of the principal judge?
Unbelievable. He's saying I'm misleading this court.
Lordship,
You may submit that, yes, we want to pay the amount from the date of order. It's okay. But they are saying that the principal judge had passed the order from date of filing.
Yes,
So
Lordship.
if the order is of date of filing, then
Yes,
obviously there will be an area. So that's what the other side is submitting.
And
Your Lordship, if you may peruse, Lordship, the order dated 17/3/2026. Accordingly, petitioner would deposit the maintenance granted by the trial court on regular basis, including arrears from the month of January, not from the date of filing, Lordship.
Lordships, the one sentence before that, if your Lordship may kindly peruse, it is very categorically said, it is made clear that there is no stay order operating in the case. What does that
There is
mean?
no stay order, but the direction is given from date of filing.
No, your Lordship, that direction was given in the scenario that the admission of the petitioner's child, of the party's child, was about to happen. And because of the fact that he was refusing to even pay me that kind of money. Eventually, he paid the fees. Eventually, he did pay the fees.
Lordship.
And I am a completely unemployed person, your Lordship.
No, Lordship, that is
And
completely
again-
false. I can show it in the record itself.
It's okay. Then now
There is
question,
no,
I can
there is
understand.
nothing, Your Lordship.
What-
I
what-
just require some time to bring
This
my
has been the consistent
things on
stand-
record.
This has
I
been-
need some time to bring my things on record. I need to file a reply.
Let me take
There has
two
to be
years
time.
to get
This
your
could,
Lordships. This interlocutory application was considered after 2 years, your Lordships.
Your
I had filed
Lordship,
the petition in 2024
if
and the interim maintenance order has come on 5/1/2026. Your Lordships was aware of the law that an interim application should at least be tried to be settled
Lordship.
between 6 months.
if I may
An
satisfy this
interim
court, Lordship.
order was granted to me after 2 years. And today they are not even willing to pay the arrears in the matter.
But,
There is no
but
arrears,
the-
Lordship.
Whether the regular basis,
There is no areas left, Lordship. There is no arrears. When this court directed me, the court directed me to pay from the month of January. It is specifically written in the order. And the thing of the delay of the interim maintenance is that she filed her assets and liabilities after 19 months of the filing of the case. It is crystal clear in the case law of the Rajneesh versus Neha. We need to accompany our petition with our assets and liabilities. Otherwise, my petition is not valid. The family could entertain the petition without assets and liabilities. And the case run 19 months without the assets and liabilities. It is your fault you did not bring on record the assets and liabilities. That is why you didn't get the interim order. Yeah, I can
Okay,
show
then
it
I
from
can
the
understand.
record.
Now,
Nothing,
question
Lordship.
is
I am
that on
just
17/3, this
I-
court or passed the order.
Yes, Lordship.
Obviously, there was a direction that from 1/6/2000, January, from the month of
I
January
paid, Lordship. I have
2026,
brought it on record.
it was directed you.
Yes.
So since then you are paying.
Yes, I have paid.
Now see, okay,
Everything
then we'll
is on
settle the
record.
matter. We will see the matter because they have challenged the order of the learned, the principal judge. So that is under challenge, I think. You have
That is what I'm
challenged. So
saying,
that-
Your Lordship. That
yeah.
itself is this petition is liable to be dismissed in limine because the
Yeah,
law
I
is
can
very well
understand.
set.
You are
This
saying
is
that
an
the
interlocutory
interlocutory order, there is
application.
no. Okay, that will be fine. Now, till when you want to file it, your
Some time may be given to me, Lordship. Today it is 18th. For second week of June, I'll within second week of June.
Second week of June. Or what you need second?
2 weeks
Take
time
first,
will be given.
first week of June then.
Okay, first week of June.
First week of June.
It is
at
much
least.
obliged.
And apart from that, you are paying the
I am paying, I have brought
regular.
on record. If you may peruse, Lordship, if you
okay,
may
then you
peruse,
can
I have
then.
filed an additional affidavit where the transactions for the month of January, February, and March is given. The copy is supplied to her. Further, for the month of April, Lordship, I have with me the transaction copy. I have paid for the month of.
That is not disputed. You have paid now.
Yes, Lordship.
The
Everything I have
question is
paid.
there regarding
And
the area amount, what she is submitting.
regarding my learned senior submission, I would like to bring on record that the delay was made by the petitioner herself.
Lordships, I will produce the records. The orders of the Honorable Family Court are before your Lordships. And the trial court record is also come. Let him not make submission that it was on my fault or his fault. Whosever fault it was, the fact remains that there is an order of the Honorable Court. After 2 years of having filed the petition, I have got this interim maintenance order.
Because
And
Lordship, they have filed it after 19 months.
Stalking.
It is
Please learn the basic. Let me finish. There is an order of the Honorable Family Court saying that I should be granted this amount of maintenance. It's only a meager amount of 18,000 per month for me and my daughter. Now that is in itself a very meager amount, but considering the fact that it is a interim maintenance granted to me, I have not challenged it anywhere else for the time being because the actual petition is still pending. The fact remains that the order which my learned friend is relying upon, 17/3/2026, the line above the line which my learned friend is reading very categorically states that there is no stay order in the matter. How is it that he's not pointing out that to your Lordships?
There is no stay order. That's why the
There is
court is
stay,
proceeding.
therefore, he is liable to pay the arrears within a period of 4 months, which was the specific order of the Honorable Family Court.
But it is also the
And that family court has that 4 months has already elapsed. Yes, he's paying me from January to February 2026 because when on 17th of March, he had not even paid me for January and February. In that context, the Honorable Court here has held that let him at least clear January, February, March immediately. It was not that he should not pay the arrears. It is very categorically stated by this Honorable Court on 17/3 that there is no stay order operating in the matter. You also may have seen that. So therefore, to say that there is there is the categorical direction of this Honorable Court, therefore they are not paying, that is incorrect, Your Lordships. There is a very categorical finding that there is no interim order. Let him pay the arrears. I have no difficulty. Let him take 2 years to file his reply if he wants to. It doesn't matter. Thank you so much. It doesn't matter to me if he's taking 2 years to file his reply, Your Lordships.
Just 1 minute, Lordship. The thing is that
Okay, then
I would like.
pass the order. Now it's you're seeking some time, no? We have
Yes,
passed
Lordship.
January. Let us see on that day itself.
Yes,
the
that
admission is
some time may be
because
given to me.
She is also raising the issue that is not maintainable because of an interlocutory order. That is it. But I can understand there are some matters where the interlocutory order can also be grounded. That can be. You're going to pass the order on the that day. You are Mr. Kashyap.
Okay.
Heard Mr. K. Kashyap, the learned counsel for the petitioner. Also heard MSRS Chaudhary, the learned counsel for the respondent. The case is fixed for admission hearing, but it is submitted by Mr. Kashyap that he needs some little accommodation to file written reply against the affidavit in opposition filed by the respondent. We have also heard both the parties in regards to some the payment of interim maintenance, and it is raised the issue raised by the parties regarding the payment of the interim maintenance from the whether from the date of order or from the date of filing. Those matters will be decided at the time of admission hearing, and endeavor shall also be made to dispose of the matter in the next date. So we are listing it at 3rd of June.
Lordship, 3rd, I have some personal difficulty. 5th of June, Lordship.
Okay, 5th of June. Okay, 5th of June.
I'm deeply obliged. And he may file the reply before that, Your Lordship, not on the last date, not at the last minute. Let him file it by 3rd of June and 5th of June.
Lordship, can it be on 4th? My senior will be on legs from 6th till 15th. Lordship.
4th.
Can it be on 4th?
4th. Okay, then 4th of June. And you submit your written reply prior to the date of the
So maybe by 1st they can file.
May it please your Lordship. This is a Jimma petition which was rejected. I am before your Lordship regarding my vehicle, mobile phone, and that seizing of my bank account and thereafter freezing. last time when it came before, the records are there. They sought time that to find out whether in between this interim period of seizing and freezing, whether 106 or earlier 102 was complied with or not. That much was, and I have relied upon two judgments I have given, and the Sundar Ambala case regarding mobile and vehicle, and the two judgments which was before your lordship. One is 24/7 SSC, page 23, and another that is online judgment reported on 10 December 2025, and our own High Court judgment 22/6 GLR 772.
Yes.
My
last
lord,
time
these
it
three
was-
judgments and Sundarlal Ambala. And my lord, regarding mobile and vehicle, I will not say anything more. As regards freezing and seizing, my lord, it was on 28/11/25 when the FIR was lost. And my lord, on the same day, 28/11/25, they have seized my lord, vehicle, a mobile phone, and that day only my information goes that seizure was done of my bank account and freezing is also done on 28/11. So in between that day, before freezing, whether they have sent it to the magistrate, which is mandatory in nature, 106, they waited, and 102 earlier. The record will reveal whether they have done it or not, because instruction will not come from on that ground. The record has to be produced.
So regarding that part, Lordship, that I have not found in the CD, Lordship, and that whether it was sent to the London court below immediately. But Lordship, 106 is regarding Lordship seizure of certain property. And whether it is related to freezing, that I am searching.
333.
Seizing আছে কিন্তু freezing ও কারণে আছে না seizure ও কারণে আছে
The judgment is
106.
This is 102. Our judgment is mandatory.
Paragraph না
Okay. Paragraph 8. One 1063, I got the 102.
CCT submitted. Eight submitted up, no?
Paragraph.
Increasing bank account liquidity.
That is mandatory, my lord. Supreme Court has also said in 24/7, and this judgment is also there.
That instruction I was actually I sought for from the IO concern that I have not received also. That is from
Because the document has to be there, my lord. The moment they send it magistrate, the information will be there, and the documents will be there.
sometimes some documents, all the documents they may not keep because also it has to be sometimes it may not keep.
That goes in favor of the man or the petitioner. Because since last 4-5 times they are taking time.
Time days.
Oh, look at time days, last 4.
And more interesting is also that amount, how much money that is there in his account that has not been reflected from any side. From the CD side, from CD, it is not reflected that how much money there in his account, whether it is a huge amount, whether it is a small amount, that nothing is. And from the petition also, we cannot ascertain that how much money is being freezed or how much money is there in his bank account.
That is the lacuna on the prosecution, madam. If they are unable to
Even
tell,
the petitioner also could.
please. This is the lacuna of the prosecution because how much amount they is going to freeze, it is their burden to prove.
No.
It's not my to say
that this much is my legal money, this is my illegal
Shifting
money.
the burden to the prosecution all the time, that is not so, Lordship, because Lordship, it is there. They can also place it in the petition, Lordship. It is their amount, their account has been seized. They can say any easily, only shifting the burden to the prosecution. Yes, I have, starting, I have stated, Lordship, that it is
It is not there.
I have
The-
admitted. But
They have said
again,
in
is
the
shifting
CD
to
it is
me.
not there. In the CD there is no document is there and no information is there.
Now, what is the stage of the case is still
for-
pending for
and-
investigation?
Investigation. Alright.
Now, see, Mr. Locker, while freezing the document, we before us only CD is there. I can understand. But obviously there has to be some order. That order, reflection order is copy of order may be there in the CD, but the original order may be in the case record also. So do you have the case record with you?
Or CD is
CD is obviously that you're saying that that order
at
which
least
is
that-
required
that-
to put up before the magistrate before passing any order of freezing and all. So that is the order of 102 earlier or now 1063. 1063 CRPC you are saying?
No, madam, 1063
BS,
of
BNS,
BNS.
BNS.
102 of
Yes, CRPC. So whether that is there or not, because
other orders, what I
because
find,
that
madam,
is
other
the
orders,
point, what Mr. Roy Chaudhary is appearing is that
other
the-
orders are there. Other orders as regard rejection of Jimma and other judicial orders are there in the city. But I can look from here.
when, as per information, when your account
28/11 on the same day when the FIR was lost.
on the
My
same
mobile
day.
phones were seized. My account was
No,
seized.
seizing of your mobile and the
And
vehicle.
on the same
oh,
day, same
okay,
day.
only
So all-
it's okay, but on freezing of your account
On the same day, 28/11.
do you have anything to show that
After some time. I will-
28/11 your account were also freeze? Is there anything?
Please, no, my lord, I don't have any doubt.
No, so.
And the
you're
rejection
saying from-
order,
You're saying from something now that your
because my
account
lord,
were.
on the same day, the instruction goes because they have blocked my account. I am on an interim anticipatory bail. I cannot operate my account. And my lord, on the same day, they have taken
How
my
many
mobile.
accounts you're in which bank?
My lord, the bank is, my lord, freezing of the bank account is there, but I don't know, my lord, the bank account is not there. My lord, let me find it out. My lord, just the account number of my bank is it is Bank of Baroda, Chaigaon, Dheka Nawari branch. Bank of Baroda, account number, page 4, paragraph 4.
Bank of Baroda.
Bank of Baroda. My lord, I have given the details.
Branch is, you have given the detail in which
To
page?
page 4, para 4.
Now, what is your report? Is there, okay, CD is there. Now regarding the freezing, whether the further
That
freezing,
report I have not
freezing
received,
of,
Lordship.
huh?
That report I have not received.
No, whether further freezing is required for purpose of
That is
investigation.
there, that is there, that is required. Lordship. It is there.
Required, as part of the IO required.
Lordship.
Okay, now then, just tell us,
That
is
violation
there
of
any
106.
report in that regard to the what Mr. Roy Chaudhary is submitting that Bank of Baroda, only one account branch or
My lord, here,
branch?
one account. That is
One account,
para 4, page 4.
Bank of Baroda.
Bank of Baroda.
So is there any further report from the bank authority that the account has been freezed?
That I have not received. That I am.
No, you have to receive. Then how can you say now?
That I have not received. Lordship, today. Today I have not received. Lordship, Lordship.
Because there has to be one report from the bank authority also that they have received the instructions or from the IO, investigating officer, or from the court order, the accounts has been freezed. So there has to be something from the bank also.
Then after some times, I will again check. Lordship.
Okay.
Right, Mr. Lordship.
528 application for question of dispur PS case.
RV Bora, you are appealing for her? RV Bora.
Lordship, the matter is pending before the mediator day after tomorrow. So
Before the mediator, day after tomorrow.
yes, Lordship. So kindly give us some days.
It's good.
See
See,
that.
if it is pending with the mediator. Your MS?
The liquids.
We have and some liquids and counsel for the petition, and also heard your MS. As Boro appearing on behalf of Mr. MS RB Bora, the learned counsel for the respondent, and Mr. B.S. Toppo, the learned additional PP, appearing of state respondent. It is submitted by MS. It's that the date of mediation is fixed on the day after tomorrow, and accordingly requested that the date may be fixed after the mediation is. Considering the submission made by the counsel for both sides, let the matter be listed. Now, you for mediation.
We have received the CD, Lordship. CD will be retained.
CD,
CD
can
we
it
have
be written or what to do?
We can retain.
Because day after tomorrow the mediation is fixed. So if something good is happening in the mediation, then it's good for us also.
No, we can say retain it, Lordship, for
You can retain it for some time, counsel. 1st of June will do, or okay. We are listing it on 1st of June.
Okay. Oh, obliged.
In view of this, let the matter be listed on 1st. Yes.
My lord, in this case,
Yes.
we have filed this petition for quashing of the order dated 7/8/2024.
So why it is in order column, basically?
My lord,
Why it is in order column?
my lord, actually what happened in this case, we have taken the steps up in the respondent number 2 and 3 several times, my lord. But they have not, I think, Lordship, they have not received the copies, Lordship. So
Yes, still awaited.
still awaited, but Lordship, see the order, Lordship, they have lost the FIR. Thereafter, Lordship, vehicle was seized, and the trial court court has
The addresses are, I mean,
yes, everything
proper.
that is given in the FIR, my lord. As per the FIR, we have written the addresses, and there was an agreement between the parties. They have given that details in that agreement also. So, my lord,
Both 2 and 3 is from PS Dispur, na?
my lord, PS Dispur.
Do one thing, Bora, you are appealing here. Now, obviously, this case is pending since long. It is of 2024 matter.
Yes, my lord.
Probably quashing.
Yes.
Do one thing, all the times the reports receive return unserved.
Lordship.
Both 2 and 3.
Lordship.
And though as the council is submitting that they have lost the FIR, so this may be proper. So in spite of that, why it is returning back, I don't know.
Whether
So we'll do one thing.
improper. My lord, see the page number 19. That is their FIR. They
Page
have
number?
given page number 19 in a vernacular, my lord. They have given their address, phone numbers, all details, but they are not receiving the. This is intentional, my lord.
Is it? It is
Because one personal vehicle they have sold, then thereafter they lost the FIR, and again they file a case and take the Jimma from the court below.
Syndicate market department.
It is under
Yes,
this.
the address is same, I think.
Same, my lord.
Sano. Delete.
This your case, your case. নয় একটু আমি হেরে গেছিলাম জিম্মারে গেছিল জিম্মা দি দিলে ঘৰত হ্যাঁ জিম্মা দি দিলে আমি মানে আমাৰ এগ্ৰিমেণ্ট কৰা আছিলে সিহঁতে কেছটো দি পেলাই গাড়ীখন লৈ গুচি গ'ল
One last can it be done that it is of dispute PS.
Lordship.
So let us issue phrase true jurisdiction only.
Yes,
In that case,
true
you-
concern PS.
Concern
Lordship.
PS.
Yes,
And in that case, we'll make a observation that you also make an inquiry regarding this service.
Lordship.
Along with that might be dusty service is
That's
It
that's
will not
be-
work.
Will additional PP, this PP office will help us
my lord.
in that case. So I think there may be intentional as you have submitted,
My lord.
may not be, I don't know.
Because my lord, vehicle they sold out. Thereafter, there was an agreement. We have filed a CR case also before the court below. Then my lord, again they lost this affair. Police seized the vehicle and they took the Jimma from the court below, my lord. That is the practice, my lord.
So now.
And now the
against you-
vehicle is with them. We have paid lots of money, 45 lakhs we have paid, my lord.
Lordship may,
Hmm.
they may take first steps through concerned PS. Lordship.
On the next set, you also make an inquiry. I'll pass the order.
Lordship, that
So
may
that,
be reflected in the,
Yes, at least a service should be there.
yes, my lord.
Can it be a short period, my lord? Because this poor PS, throw them will
Very short to you.
not
can-
very short, my lord. It's
Let us see. Hard MS SKNR still on counsel for the petition. And also hard MS SH for an additional PP bring on behalf of state respondent. As per office
Oh,
to
did you must-
14/5/2026,
We will
given
remove.
that the service is still awaited for the respondent number 2. In that context, MS Nargis submitted that they have taken steps to the respondent number 2 and 3 on many occasions, and the address given in the address given in the FIR, which is considered to be the proper and the present. In view of this, let a fresh notice be issued to the respondent number 2 and 3 through the jurisdictional police station and the office of the public prosecutor of the additional PP will also make an inquiry in regards to service of notice on the respondent. Very short, it will not do either maybe 1st or 2nd of June.
first week of June, my lord.
1st week of June,
My lord.
2nd of June.
Date may be weeks, my lord.
2nd of June.
2nd of June.
Yes.
My lord. Obliged. We'll take steps, my lord.
Yes.
By-
Next step, they will make an inquiry into that.
May please the lordship. Here step has been taken, my lord. So police, but service report awaited, my lord. So we some short date may be given because we have some urgency in this case, my lord. One of the petitioners.
Interim was there in your favor.
Yes, my lord. Interim is my favor, my lord. Yeah, my lord. All the family members are facing when they lost the affair against the father, mother, sister, brother of that and that the person with whom she had some relation, my lord. So all are facing problem. One of the petitioners is, my lord, in provision in the Kharagpur IIT. Because of this case, his service is not regularized. Because of this case, my lord. There's some urgency is there, my lord. So we have already taken step, my lord. So in first week of June, my lord.
What more do you have taken steps?
Yes,
To
ma'am.
jurisdictional police station.
Yeah, through police station.
Police station.
Both is the police station.
Hard MS Ilane counsel the petition, also hard MS SH for Ilane additional PP appearing of state respondent. From the office note, it reveals that the service is still awaited for the respondent. However, it is submitted by MS Gauhati that they have taken steps through the jurisdictional police station and the police station, but feel that the service is still available. In view of this, let the service be awaited till next date of listing. However, the learned additional PP is also hereby directed to make communication with the concerned police station regarding the service of notice on respondent.
4th of June.
4th of June.
Yes, ma'am.
4th.
Interim may be continued.
Yes, it will be continued till next.
Must oblige.
May it please, Your Lordship.
Yes.
This is an IA, Your Lordship, filed seeking some correction, Your Lordship, of some typographical error. A judgment was passed, order dated 28 to 2025 by this court, Honorable Court, Your Lordship. There are some typographical errors. The case number, Your Lordship, complaint case number is some error. Your Lordship, the complaint number should be, Your
In
Lordship.
cause title or where?
Yes, Your Lordship, the
In
cost
cause
title.
title.
The complaint case number should be, Your Lordship, 4683C of 2017. But instead, it's been mentioned as 3204 of 2017, Your Lordship. The judgment is at page number 9, Your Lordship.
No need required for judgment. Your cost, you're seeking amendment or correction in your cost title or where you are seeking?
No, in the judgment, Your Lordship.
Oh, in the judgment?
Yes, Your Lord.
Full judgment. Yes.
Paragraph 19 and 20.
19 and 21.
21. Paragraph 19 and 21 of the judgment dated 28 to 2025.
Paragraph 19 and 20.
21.
So basically the case number is
Yes, Your Lord.
is not correct, na? 19 and 20. So it can be corrected. Do you have any objection? You are Mr.
You, Bharadwaj, Your Lordship, on behalf of Mr. T. Deuri.
You Bharadwaj.
Yes, Your Lord.
You Bharadwaj, appearing on behalf of Mr. T. Deuri, the learned counsel for the applicant, and also heard Mr. N. Sharma, the learned counsel, appearing for the respondent. This interlocutory application has been filed for correction of the modification of correction of the typographical inadvertent mistake while passing the order in judgment and order dated 28 to 2025 in criminal petition number 1132 of 2018. Next, but it is submitted by Mr. Bharadwaj that inadvertently in paragraph number 19 and 21 of the judgment, the number of the complaint case has been mentioned as 3204 of the 2017 instead of 4683 for C of the 2017. Accordingly, submitted that the correction is required in the order passed in criminal petition number 1132 of the 2018 by this court. Next, Mr. Sharma, the learned counsel, appearing on the respondent, there is no objection. Accordingly, the petition is allowed and the correction has been accordingly made, will be made accordingly made in para number 19 and 20 by inserting correct complaint case number as 3204 of 2017 by deleting by correcting the case number of complaint case number 46383. Oh no, ulta. Inserting the complaint case numbers 4683C of 2017 instead of incorrect mention of complaint case number as 3204 of 2017. Will be read as under 19 and 21 will be according to it.
Much obliged.
I
May it please your lordship. Lordship, in this criminal division, I have been appointed as an amicus curiae. Lordship, although I have been furnished with the memo of revision, but the evidence part, lordship, although I went through the record during the court hours, but
how the amicus is there because it's a criminal division petition?
Lordship.
Because
Why
none
am-
appeared
Perhaps
on,
none
Oh,
appeared
none
on the
appear for the
on 5/5/26, Lordship,
none appear for the petitioner.
petitioner.
Oh, acha. So you have been provided with the
Memo
copy of
of revision, but not with the PCR, Lordship. Copies, mainly the copies of the evidences.
how it will be now provided?
Lordship will give a direction that
To registry.
to registry. Lordship. Copies of deposition
Copy
may
of
be
the
furnished. with
deposition.
the parties.
Well, relevant documents. So you are MS A Sharma.
A new, Lordship,
Oh, A new. Acha.
Appearing
Hard
amicus.
MS A new.
appearing on amicus.
The learned amicus appearing for the petitioner. Also hard MS SH for the learned additional people appearing on behalf of state respondent. It is submitted by MS Nev that though she was provided with the copy of the revision petition, but she is not provided with the other relevant documents which will be required for the hearing of the case. In view of the next part, in view of this, the registry is hereby directed to supply or to furnish all the relevant copies to the learned amicus appointed on behalf of the petitioner. This the matter accordingly after supply of all relevant copies to the learned amicus as on a date fixed by the registry. Okay, let your service be completed, then we'll pick up the matter.
Lordship.
Please take. Okay.
May I please your lordship, my senior is on another court. Pass over the matter for the time being.
Time being, we don't have. Yes, Mr. Locker, have you gone through? We need 2-3 things. One is at the time of freezing of those accounts, bank must have received at least something. Because freezing will be done from the, if he got something from the, either from the IO or order from the court, there has to be something, that is one. And number two, whether those 106, complying of 106, whether that was note was produced before the magistrate concerned, before praying for the freezing of the account. That is the two will require. Because there are some instances or some occasion may be mandatory required, may not be, there are lots of observation. Now, but the question is that whether those were complied with or not, that's the main issue. So in this case, there you have find nothing.
Regarding first query, also that whether that has been that I have found, and they have informed they had requested the bank authority. The IO has requested the bank authority to freeze the account. That I have found in the city.
But IO had requested while filing the prayer for request. Was there any
supporting
observation that any supportive anything?
No, nothing.
Then how by their own though they cannot? There has to be something.
That order there, that order now, just now I asked him again that whether you have filed any application before the court below for freezing that account, or immediately after freezing that, whether you have informed me. That he informed me that he was not the he was not the investigating officer for who was investigating the matter initially. He was subsequently handed over this case. So he has to ask his senior person who has investigated it earlier. So he's just
these things are required, otherwise how can we pass the order? Because there has to be either maybe observation, maybe either side or this side. That is different thing.
Only that issue has to be clarified as to whether he has informed or not.
That their compliance is definitely necessary.
But regarding order, I have searched read out every order. Annexed
But will you get that order in the this record? Because sometimes it happens that record is put up. I mean, any prayer for the IO is put up in a record. So record there maybe, I don't know at this stage. So
if the present IO can clarify it, confirm it that the earlier IO has made such prayer, then definitely he will get from the court below also. He will get a copy of from them.
From where you will get now?
Today not possible. Today may not possible. But
But Mr. Roy Chaudhary is insisting on it, but obviously it is pending. It is pending since 2020 anyway. And they're freezing and seizing all these things in the month of November 2015 onwards. There are certain judgment in regards to mobile handset or these things, but the freezing, whether those accounted money was for what kind of money was there any this case related money was deposited for, there may be some reason for why the accounts were freezed. Now, what amount of account was freezed, whether it was account is, he's saying that only account is there. So there has to be now just clarify all these things and see if counsel, because I have already exhausted my list. So we cannot pass it for time being. So what we'll do, yes, Locker, how will you take time now?
Day after tomorrow, Lordship, I will anyhow I will suggest something.
Tomorrow, yes, 9 or
If it is possible. Only that to that
tomorrow
extent.
is already there.
It will not take some much more time.
Possible now.
He's on it.
Right, no? Roshni, phone ko koi- Mari bro.
He's saying that we don't have any date. Day after tomorrow also, tomorrow already list is there. Day after tomorrow, many completely 25 fixed matters are there. 25 fixed matters are already there. So 25 and 26, there are many matters. So at least on 26. 26 we can fix. Otherwise, we don't have any date also.
On that day, this will be disposed of anyhow.
Ah.
Matter will be disposed of.
This way or that way.
Yeah.
Whatever.
Sorry, my lord. Lift
It's
is not
okay,
working.
it isn't. So
Lift is not
what Mr. Locker has submitted, he took some information from the concerned IO.
Oh.
But the present IO who is now presently investigating the case was not the initially he was not there. So he will take some information. So Mr. Locker was suggesting that it may be fixed on day after tomorrow, but day after tomorrow is not possible on our part. At best, we are fixing it on 26th, that on that day we try to dispose of the matter on 26th.
No. That day may not be any other option, my lord.
No, that day, on that day it will be disposed of anyhow. Right. This way
Because
also,
if there is a
And you take the, I mean, from the state, you represent this one because
Lordship,
you have gone through already. They record
right.
because they will call you only, even if you are not, suppose on that day, if you're not addressed with the court, but try to manage this one because it is pending. Only last week also, there was some date that you're on appraisal of the record. So take those information is whether in. And the when the report was filed by the IO, is there any why further freezing is required? Is there any development? Is there any, do you go through all these things also? Because further freezing will be required is not sufficient. There has to be something. Why it is required? Because already in the month of November itself, there was a freezing order of freezing or it was freezed.
Yes.
What is the bank account? Let's see.